Yes.
All right.
Now you guys are really changing seating positions on me. All right, everyone, please be seated. And we are back on the record. Ladies and gentlemen of the jury, it's the court's understanding that you've reached a verdict. Is that correct?
Yes.
And is it unanimous?
Yes.
All right, if you will hand that to the deputy for me, please. Thank you, Deputy Welch. All right, if the defendant will please rise. All right, the verdict form reads, we the jury find the defendant Joseph Contreras guilty of aggravated robbery as charged in the indictment. You may be seated. Is anyone requesting that the jurors be polled?
Yes. Judge.
All right, ladies and gentlemen, of the jury, I'm going to ask you if this is your verdict. If it is, just respond yes. Does everyone understand? All right, we'll start on the first row at the end. Is this your verdict? Is this your verdict?
Yes.
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 And we'll start at this end. Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? I'm sorry, I can hear you. All right, thank you. All right, what's going to happen now, ladies and gentlemen, I'm going to have you go back to, well, actually, I'll give you your lunch break now, and then we'll come back. Let me see, it's almost 1. We'll come back at 2:30 for punishment. So that'll give you a chance to walk around. Remember your oath to the court. So still do not discuss this case with anyone. Understand?
Yes.
All right. And make sure your badges are displayed. If everyone will please rise for the jurors. All right, everyone, please be seated. All right, so defense, the state is requesting that your client be printed. Do you have any objections to the motion? All right. Then, Mr. Contreras, there's going to be a fingerprint examiner to come in just to examine your prints, okay? All right. All right, then with that, we're going to go on a recess with this case. I'm having us come back at the time I suggested because, of course, I have an afternoon docket. So state if you'll make sure you take care of that.
Sounds good.
I'm sorry, what time, Judge?
We're coming back at 2. Did I say 2 or 2:30?
You said 2:30.
All right, so we're going to be back at 2:30 and we'll start exactly at 2:30. I have an afternoon docket that starts at 1:30.
Just for timing for the court's awareness, I believe we'll just have one witness for the fingerprints. That's the entirety of the state's punishment case.
All right, so defense, is your client going to plead true or do you need to discuss with him about that?
I'd like to discuss with him about that.
All right, so let's see if we can. All right, and state if you will just step outside so they can discuss in private.
For sure.
You're welcome. And Deputy Moore, could we be on mute? And no video, please.
See y'all. We're gonna do our jump on Zoom, Judge.
Okay.
Thank you all so much for the party, Judge. That was very nice. I was so completely surprised by it.
See.
I don't know if we need to stop talking to alternates or what, because they can make you go crazy in your head.
Yeah, that's true. But I mean, you just never know.
Yeah.
All right, we are starting.
We're starting.
Yes.
Going up there too, because we're gonna also have,
Well, we may not have, we've just one minute.
All right, let me make sure I have everyone on. Just give me a moment.
did we exchange a microphone or?
Yes.
It's that was a question?
Thank you.
Thank you.
All right, everyone, please make sure you're on mute. You are in the 187 District Court. You're here by Zoom. These are the rules of the 187 District Court. One, it's Thursday, so everybody should be happy because tomorrow is Friday. We treat everyone with respect. I'm going to open the breakout rooms. When I open breakout rooms, it's going to invite everyone to go to a breakout room. Do not, I repeat, do not go to a breakout room unless you're specifically called by name and assigned to a breakout room. The attorney's name will be called, the defendant's name will not be called. If you do not hear your attorney's name, it's because your attorney either is in person in another courtroom or had to Zoom in another courtroom. So everyone, please be patient. To all of those who are walking around, you need to find a space and you need to remain stationary. Ms. Garcia, I don't know where you are, but I do know that you're inappropriately dressed for court. So you need to find a jacket or something. Deja Garcia, you need a jacket or something. All right, attorneys, if you have a plea bargain agreement with the state, no matter how small you think that plea bargain agreement is, you need to put it in the chat box to Ms. Ferguson. She'll be listed on the screen as Ferguson Coordinator. Just a moment. Let me make sure that no one has one. All right, attorneys, what she will need to know is she will need to know whether it is for probation, whether it is for regular probation, or whether it is for time. If your client is on bond, she will need to know your client's email address. To all the attorneys, I'm the only one who can excuse you, so please do not text, chat, call Ms. Ferguson asking her for a reset, because I'm the only person who can give a reset to you. Just one moment. To all of the defendants and those who are accused, this is a courtroom. What that means is you need to behave appropriately. Whatever you could not do if you were present in the courtroom, you cannot do on this Zoom screen. If you behave inappropriately while you're on this Zoom screen, your Zoom privileges will be revoked and you will be required to appear in person in the 187 District Court. It does not matter if you're out of town, out of county, out of state, out of country. You will be required to appear in person in court. So everyone behave appropriately. I'm going to call the names of the attorneys. This is the order in which you'll appear. Elizabeth Russell, Jody Sawyers, Jeff Kesey, Michael Goins, Scott McCrum, Andrew Froelich, Alice Warburton, Mick Aguilera. Is there any attorney whose name has not been called? Ron Zimmerman, I see you.
Elizabeth Settle.
Anyone else?
Elizabeth Settle, ma'am.
I have you. Anyone else?
Okay.
All right, then. I'm going to assign you to breakout rooms. Attorneys, it would help the process move quicker if you will add to your name the name of your client and whether or not it is criminal trial division or family violence. Elizabeth Russell?
Yes, Judge.
Yes, I'm going to send you to breakout room number 3. Thank you for changing your name. Jody Sawyers, I'm going to send you to number 4. Thank you for changing your name. Jeff Kesey. Jeff Kesey.
Yes, ma'am.
You're a defendant, you're not the attorney?
No, ma'am.
All right, thank you. Michael Goins, thanks for changing your name. I'm going to send you to number 5.
Your Honor, I think this is just a status update for you.
All right, then just give me a moment.
No problem, Your Honor.
Thank you. Michael McCrum, I'm going to send you to number 5.
It's Scott McCrum, Judge.
Oh, Scott. Oh, sorry, tell your
No
brother.
problem.
Tell your brother I said hi. I'm sending you to number 5.
And I don't know if it's just me, Judge, but your audio is really breaking a lot.
I know. We'll see what we can do about that. So I'm sending you number 5. Andrew Froelich, I'm sending you to number 6. We're going to take care of that after I sign everyone. Alice Warburton.
Yes, Judge, I'm here for Israel Elizondo family violence.
All right, I'm going to send you to number 7.
And Tommy Stolhansky has found that if audio is cracking on the host side, that if you make some people, like half of them, turn off their cameras, it improves. So
Okay. Thank you.
I found that.
But we're going to take care of it. Mick Aguilera, I'm going to send you to number 8.
And Judge, when Sharon Thorne shows up, can you send her there also because she has a companion case?
Yes, and she's just. Ron Zimmerman, I'm going to send you to number 9.
Thank you.
Elizabeth Settle,
Yes, Judge.
who's your client?
It's Deja Garcia.
Criminal trial division or family violence?
Oh, we're here for a plea, Judge. It was reset from last week. It was Ryan that was handling it, Judge.
All right, just give me a moment. All right, is there anyone else who needs to be assigned?
Yes, Your Honor, I do.
All right, who's your client?
Kristen Smith, case number
No, just
2022
need to know if
CR,
it's criminal trial division or family violence.
criminal trial division.
All right, I'm gonna send you to number 10.
All right.
Also need to be assigned, Judge.
Who's your client?
Richard Thomas,
Criminal trial division or family violence?
family violence.
I'm gonna send you to number 11.
Thank you, Judge.
You're welcome. And everyone, just give me a moment, please. All right, then I am going to zoom in the back. When I zoom in the back, you'll see my photo. Can you make me host?
All right. And Ms. Settles, you say there's a plea on your case?
Yes, Judge, we had begun it last week and then you reset it to have the mother and grandmother of Deja come and testify as to the no contact or no harmful or injurious contact order.
Okay, all right. Just give me one moment on that.
Okay.
Judge, can you put me in a breakout room with my client? He's in custody.
All right, you're in number 10.
With my
And
client.
Mr. Smith, if you'll go to breakout room number 10, please.
Thank you, Judge.
You're welcome. Are there other attorneys who've zoomed in?
Yes, Your Honor. Chief Christopher. George Sharman, Judge.
All right, Mr. Lewis, who is your client?
Jeffrey Kesey.
Is it criminal trial division or family violence?
Family violence. It's actually CPS related, so they switched me over to family
All right,
violence.
I'm going to send you to breakout room number 12.
Thank you, Judge.
Nathaniel Navy, I'm going to send you to breakout room number 13.
Thank you.
Natasha Torres, I'm going to send you to 14. Martin Guerrera, I'm going to send you to 15. John Kuntz, I'm sending you to 16. George Sherman, who is your attorney, who is your client?
Polinar, he's present. I've got him in the other room online here. Let's see here. There he
Criminal
is.
trial division or family violence?
This is a plea on a criminal case.
All right, has all the paperwork been completed?
It has been, and they told us they'd have somebody who speaks Spanish to help us with the plea.
All right, we'll get them here. All right, Bobby Gibbia, I'm going to send you to number 17.
Thank you, Judge.
Is there any other attorney who hasn't been assigned? Yes, Mr. Flores, who is your client?
Good afternoon, Judge. I've actually got two. They're both family violence. Jose Raimundo Perez, who is online, and Marcos Patino, who is in the room with me.
You said Partino?
Yes, Your Honor.
All right, I'm going to send you to breakout room number 18.
Thank you, Judge.
You're welcome. Brenda Levinstein, who is your client?
My client is Maple Hughes. It's a family violence case.
Sending you to 19.
Okay.
Any other attorneys who've not been assigned? All right, then we're going to start with Elizabeth Suttle.
I have not been assigned, Judge. I'm sorry, Albert. I was raising my hand. Okay.
All right, I'll send you to breakout room number 20. All right, and is there a family violence prosecutor available? All right, just one moment. Let me find one. All right, Ms. Ferguson, can you have the interpreter come in, please?
Yes, ma'am.
All right, Angela Blake, you have Mons?
I do, Judge. You put me in 17, I think, with the Gebbia instead of.
No, I moved you.
Oh, you to be in the same room as Gebbia?
Yeah, I had moved you to 8. I had moved you to 17.
Okay. I think, yeah. So just wait there with Bobby Gebbia.
If anything to be on Zoom.
All right, Mr. Goins?
Yes, Your Honor, I'm here on Mr. Lionel Young.
Yes.
He has been found incompetent and he's currently waiting to bed to burnings.
All right, just one moment. All right, Ms. Ferguson, I'm Mr. Young. Can I have another date, please? If you could place that in the chat box. And if you can check with them and find out when he will be transferred, because I see that we've been waiting for a transfer since February. That's what I have.
Your Honor, the magistrate judge ordered them to contact Vernon to see about immediate placement because it's been since December. And last week it was ordered that he be forced to take his medication, just so you know.
All right, thank you. All right, we're going to come back on July 28th.
Thank you, Your Honor. May I be excused?
You may be excused.
Have a good day, Your Honor.
Thank you. Norm, I sent you a message in the chat box. All right, and attorneys, when you're ready, if you'll just raise your hand for me, please, and we'll take that matter up. No, I see your hand, Mr. Thomas. I mean, Mr. Baez, just give me a moment. All right, what is happening with Mr. Early? Yes, what is happening with, oh, you're on Richard Thomas and not Thomas Early, just one moment.
Yes.
All right, what is happening with Richard Thomas?
We can't get to an agreement, Judge. The client's not gonna accept that offer, so we need to set it for trial.
Okay.
Unless the prosecution, of course, dismisses the case, but I don't think they want to do that. So
All right, did you speak with them?
I did. We've gone over it several times.
All right, Ms. Ferguson, I need a jury trial date on. Thank you. Okay. All right, we're going to get a jury trial date for you in just a moment. And Ms. Ferguson, I put it in the chat for you. All right, on your case, Mr. Thomas, we're going to come back on June 14th. That's your jury trial date. You'll need to appear in person in the 187 District Court, dressed for trial on June 14th at 9 a.m. Do you understand?
Yes, ma'am, I do.
All right, your plea bargain deadline has expired, so the court will not accept any plea bargain agreements. You understand?
Yes, ma'am.
All right, you're excused. We'll see you then.
Thank you.
You're welcome. All right, is there a family violence prosecutor available for the plea on Miss Deja Garcia?
Judge, I'm not familiar with the plea, but I can step in.
All right, thank you.
Judge, do you want me to refresh you real quickly on what
No,
happened
I
last?
remember.
Okay.
Yes. Outside the plea bargaining agreement was no harmful or injurious contact. You said your recollection was that it was supposed to be her to have contact. And I
Right.
wanted to have the parties who are, the state was requesting no harmful or injurious contact with here, so that I could see what they had to say. All right.
Correct, Judge. And they are here, Judge.
Thank you. We're going to go on the record in 2022 CR 2514, State of Texas versus Deja Rosette Garcia. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Elizabeth Settle for the defense.
And are you Miss Garcia?
Yes, ma'am.
All right. A plea was entered on May 19th to count 1. Count 2 was waived without objection. The defendant applied for deferred adjudication. The court found there was sufficient evidence to find her guilty. However, deferred finding of guilt because she had applied for deferred adjudication. According to the plea, well, outside the plea bargaining agreement, there was a no contact request for Roseanne Garcia Heisig and the grandmother, and a mild evaluation. And at the time the court was going to make its judgment, the court requested that if there was a question of whether she's to have contact or not contact with the persons listed, that the court would want to hear from those persons. And defense, you say you have those persons here?
Yes, it's Roseanne Garcia. I believe that's the mother, and then the grandmother is Dora Garcia, and they're together.
Okay. Excuse me, person on the iPhone in the head bonnet laying down, who are you and why are you on Zoom in a bonnet?
Oh, am I supposed to take it off? I didn't know I wasn't supposed to wear it. My bad.
Well, here's your bad. Your bad is your Zoom privileges are revoked. You need to be dressed appropriately for court, which you are not, with your top open. So the courtroom is located at 300 De La Rosa on the 4th floor. So get thee to the courthouse. Your Zoom privileges have been revoked. And if you do not appear in the 187 District Court today at 300 De La Rosa on the 4th floor, a warrant is going to be issued for your arrest. Do you understand?
Yes, ma'am.
All right, Ms. Settle, who is the witness that you're calling?
Call Roseanne Garcia.
All right, Roseanne Garcia, if you could raise your right hand for me, please, and unmute yourself. Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Your Honor, I couldn't hear what you were saying.
All right, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record, please.
My name is Roseanne Garcia Hisik.
All right, defense?
Thank you, Judge. Ma'am, how are you related to Deja Garcia?
I am her biological mother.
Okay, and we're here today to discuss whether or not the judge is going to impose a no contact order with your daughter during the term of her probation, or a no harmful or injurious contact order during the term of her probation. So the question that we have for you today is, do you want to have contact with your daughter during the next 3 years?
Yes, I think it is very important that I do keep contact with my daughter. I am her only support system right now, and her father is out of state. So we're recently reunited after she aged out of foster care, and I'm like the only one that she has right now as a support system.
Okay, and does Deja has she had some mental health issues in the past?
Yes, she has had some mental health issues in the past because of her son being put in foster care. She's taken it very hard. I am trying to help her get assistance with mental health through Center for Healthcare Services, but they're really, really backed up. So as far as mental health, I don't know what to do next, but I really think it's very important for her case.
Do you think it would be beneficial for her and the whole family if she has some special services through this probation?
Yes, Your Honor.
Okay. All right, is there anything else you'd like the judge to consider when she's making her decision on whether or not you can have contact with Deja?
I would like to the judge to take it into consideration that I'm her only support system. she doesn't have like really no aunts or uncles, or even my aunt that had adopted her as a support system, and it's like really hard for my family right now. as we're
Okay,
going through this.
Ms. Garcia, are you in fear of your daughter? Are you
No,
afraid of her?
no, I'm not.
Okay, that's all I had, Judge. I'll pass the witness.
Hey,
Just a couple questions. Ms. Garcia, how are you going to ensure that you and your mother are safe from the defendant?
I would like to see what the court can do to help her get mental health services, because all of this stems from a problem that she's having with her mental health. And I would like to see if she could get some kind of mental health. Doing it on our own is sort of hard because I don't have like the connections to get her in a center for healthcare like as soon as possible. On my behalf, I would have to wait, but if there's something that the court can do, if there's a program that they can help her get into to address her mental health, or like get some kind of psychological evaluation to see where her mental health is and see what needs to be addressed.
No other questions.
all right, Ms. Garcia, where's your daughter right now?
She is staying with my brother right now. She is awaiting an apartment through Thrive. It's a program for adoptive foster children or whatever, and her apartment is coming up soon.
All right, why did you lose custody rights to your daughter?
I was struggling with addiction when I was with her father. I left her father in 2014.
All right, is there anything else from either side?
Judge, just if you would like to hear from the grandmother, who I believe was part of that no contact request. I will call briefly Miss Dora Garcia.
All right, could you raise your right hand for me, please, ma'am? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Dora Amalia Garcia.
All right, defense.
Ms. Garcia, is it your wish that you be able to have contact with your granddaughter during the term of her probation?
Yes, definitely. Yes.
Okay, and you have appeared in the misdemeanor court on her behalf a few times, isn't that correct?
Yes.
Okay, and you also asked that judge to lift the no contact order, correct?
Yes. Ma'am.
Okay.
Yes. Ma'am.
And do you feel safe? Do you believe you'd be safe around Deja?
Yes.
Okay. Thank you. I'll pass the witness, Judge.
All right, state any questions?
No, Your Honor.
All right, any other witnesses, defense?
No, Your Honor.
All right, this is what the court is going to do. Court is going to sentence you to 3 years deferred adjudication. There's a $1,500 fine to be probated. CPS compliance. This is run concurrent with County Court Cause number 668870.
Judge,
Yes.
I'm sorry, that 668870 has been resolved. That was a JSAT.
Okay, it's listed in the.
Well, that just happened the day that I got that paperwork, so it kind of all overlapped.
All right.
And Judge, also one other thing I just wanted to clear up for the court, that she did lose her child in the CPS case, so she's no longer working with CPS.
Okay. All right, and what about cause number taken in consideration 672232? Is that still in existence?
That was taken into consideration with the assault charge, Judge.
All right, so we don't. In this case, or no?
No, it was with the misdemeanor. It's already been dismissed.
Okay, well, I will remove that.
All right, sorry.
So that's okay. It's a $1,500 fine to be probated. Well, let me start over, Brent. I'm sorry. 3 years deferred adjudication, $1,500 fine probated, 150 hours of community service restitution. 40 of those hours will be waived if she provides proof of a COVID vaccination. Court is not requiring the COVID vaccination, but if she's completed it, then 40 of those hours will be waived. parenting classes. And once she completes the parenting classes, the remainder of the community service hours will be waived. No harmful or injurious contact with Roseanne Garcia Hissick. The last name is Hisk. Or what is the grandmother's name, Ms. Settle?
Dora Garcia.
You said Dora?
Dora, D-O-R-A.
Okay, Dora Garcia. MIC evaluation. Follow the recommendations of the MIC evaluation. Ms. Garcia, could you unmute for me, please?
Deja.
That's fine.
Yes, if you're drug tested today, what are the results going to be?
What was that, ma'am?
If you're drug tested today, what are your results going to be?
They'll be clean. I smoked weed like a few days ago, a week ago, so it might just come out dirty for that. Other than that, I've been clean.
All right, outpatient treatment with probation. And yes, probation, if you need to do a TAP, you can do a TAP. There should be field visits 2 times per month, random. There should be no unsupervised contact with minors. There should be regular reporting by Zoom or in person. So if for any reason you're not allowed or cannot do Zoom, you'll have to report in person. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors. And there's to be random UAs. Ms. Garcia, is there anything else you need from the court in order to be successful?
No, ma'am.
Probation, is there anything else that Ms. Garcia needs?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we'll go off the record. Good luck to you, Ms. Garcia. I'm going to send you to breakout room number 1. Probation will meet you there and go over your conditions. Defense counsel, you can go to number 1 with her. And you can both be excused from there once you've spoken to probation.
Thank you, Judge.
You're welcome.
Thank you. Can you add me back to the breakout room, please?
You already are there in
it didn't
breakout
let
room
me.
number 1. You need to just go to
Okay.
breakout room number 1.
Okay.
Elizabeth Russell.
Yes, Judge, we have received an offer from the state. And I'm gonna double check with my client, but I'm pretty sure we're not gonna accept the offer. We need to be set on the trial document.
All right, I'll send you to breakout room number 3. Have you spoken to your client?
Not today. I need to speak to him again
All
today.
right, Mr. Marshall, I'm sending you to breakout room number 3 with your attorney. Attorney, you can go back to number 3.
Thank you.
Sure. Albert Gutierrez.
Yes, Judge, I conferred with Mr. Villarreal, and the last time we were here, we were talking, I needed to see the child safe video, which I have seen now. It's a 36-minute video. However, there are some glitches in it. So I got to see probably about 2/3 or some sort of corruption in the file. And IT, DA's IT is working on that. But I think I have enough in there to be able to visit with my client about it. And I need to show him his video so we can discuss the offer that has been made to the state, and they would like either a no or potentially a counter offer. So We have basically completed what the court asked us to do, except there is a problem, a little corruption in the child safe video.
All right, Ms. Ferguson or Mr. Sereno Paul, can I have a jury trial setting? This will be your jury trial date, Mr. Gutierrez, in your plea deadline date.
Okay, thank you, Judge.
And Ms. Ferguson, if you can put that in the chat box.
Your Honor,
Yes.
it's Elizabeth. Deja didn't make it into the breakout room, so she's logging back on. If you could send her back to breakout room 1.
Yes.
Thank you.
You're welcome. All right, your plea deadline date and jury trial date is going to be August 2nd at 9 a.m. Mr. Sereno, you'll be brought over from the jail dressed in whatever clothing you have at the jail. If you wish to be dressed in something different, then you will have to make arrangements with your attorney. Mr. Gutierrez, if there's an issue with the clothing exchange, let the court know and the court will see if we can help expedite that. All right, you're excused. Ms. Ferguson, Serrano number 12 can go back. Jody Sawyers.
Yes, this is Jody Sawyers.
Yes.
Yes, Your Honor. We're here on Thomas Early,
Yes.
and we need to ask for a reset. The state is requesting additional evidence in this case that they haven't received yet.
What evidence have they not received?
It's a body worn camera from a prior incident that happened 2 weeks before, in which their complaining witness was arrested, and it involved Mr. Early and is completely relevant to the events that unfolded 2 weeks later.
All right, I previously set this for body cam. This is the last setting that will be set for a body cam for an incident before this incident case. Ms. Ferguson, can I have a 2-week reset on Thomas Early, please? All right, we're going to come back on June 16th.
And Your Honor, I actually have a vacation notice on file for that date. Can we come back the following week on the 23rd?
Ms. Ferguson, can you move? What are your vacation dates?
It's the 10th through the 17th. So I'm gone that week before the 16th.
All right, Ms. Ferguson, can I have another date outside of the 10th through the 17th, please? All right, June 23rd.
Thank you so much, Your Honor.
You're welcome. You and your client are excused.
Okay, thank you.
You're welcome. Albert Flores.
Yes, Judge, I'm back. I conferred with Mr. Villarreal on both cases. I just need a little bit more time with the discovery, and I think he needs to speak with his complaining witnesses before he can make me an offer on these cases. I think we came to an agreement, at least on one of them, on modifying bond conditions, and we're still working on the other one.
All right, Ms. Ferguson. The person in your office with you, is that Jose Perez?
No, Your Honor, the one in the office is Patino. Mr. Perez, it says Raimundo's iPhone, I think.
All right, Ms. Ferguson. On Jose Perez, can I have a 30-day reset for discovery? And this will be the last reset date for discovery. All right, we're going to come back on June 30th. And in Jose Perez's case, what exactly are you needing from the state?
No, Perez was the one you just reset, Judge. Patino's the one that's in the room with me.
No. On Jose Perez, I'm trying to understand what is not available. Do you have all the discovery?
I actually don't know if it's all available. I just haven't got to some of the videos, Judge. And I'm asking for more time for me to be able to go through the discovery.
All right, did the state make an offer on that case?
No, I think they've got to speak with their complaining witness on both cases, Judge.
All right, then when you come back on June 30th, on that case, the state is to have made you an offer and you're to have reviewed the discovery.
On Bettis.
Yes. What is happening on Marcus Patino?
Same thing, Your Honor. I don't think they've spoken with the complaining witness on that one. On that one, I do have to go access child safe videos, which I have not done.
All right, Ms. Ferguson, Mr. Patino is going to be on the same day on June 30th. All right, you are excused and your clients are excused.
Thank you, Your Honor.
You're welcome.
Mr. Bettis, you can log off.
All right, Mick Aguilera.
Good morning. Sharon
morning.
and I visited, Sharon Thorne and I both visited with Ryan. We have an agreement to plead to both cases. Ryan's pretty certain he can't get the paperwork done today because he's also in trial with you. You mentioned an ag robbery, or he's in an ag robbery trial somewhere. He's all decked out, ready to roll. He can't get the paperwork done today. If we can come back on another day to consummate a plea.
All right, Ms. Ferguson, on Mr. Frank Garcia, is your client in custody or on bond?
Oh, he's in custody. And it is a time deal.
All right, Ms. Ferguson, on Mr. Garcia, can we call him back on Tuesday? All right, Mr. Garcia, are you going to come back on Tuesday for your plea?
Yes, ma'am. Thank you.
All right, thank you.
Hey, can you also put us in a breakout room with him real quick? We gotta give him the good news.
All right.
Thank you, Judge.
You're welcome. If you all will go back to room number 8, and Mr. Garcia, I'll send you to room number 8.
All right.
Thank you.
Thank you, Judge.
You're welcome. Well, actually, Mr. Garcia, you're already in 8. Let me move you to the 9 just so you'll be able to see it pop up.
Okay, thank you.
You're welcome. All right, so Ms. Ferguson, Frank Garcia is May 31st. All right, Mr. Garcia.
Judge.
Yes, what is happening with Smith?
Judge, I'd like to ask if you would give me a 2-week extension on this plea deadline. My client wishes me to go over discovery with him again before he makes a decision. We have an offer, but it's quite a bit to go over with him in this session today. If you could, I would do it. I would ask for only 1 week, but I think I'm going to be in trial next week in the 437th. So if you can just give me 2 weeks, I'll order him when I have a chance and go over this discovery and then report back to the court on whether or not he's going to accept the agreement or not.
And it's Christian Smith, correct?
Yes, Christian Smith, Your Honor.
All right, Ms. Ferguson, on Christian Smith. Mr. Garcia, today is his plea deadline date.
Yes.
All right. So I'm going to have to recall it for next week.
I'm asking for the following, Judge, because I think I'm going to be in trial in the 437. That's the only reason. if you would just accommodate me just until the following week.
All right, Ms. Ferguson, can you set with Mr. Smith for, in 2 weeks, please? All right, it's June 7th.
Okay, Judge, would you just put me in the breakout room with my client so I can have one more last conversation with him and then excuse us from there?
All right. No, he needs to come back to the main room after you finish.
Okay. If you'll just I'll go back to the breakout room with him, all right?
Okay. All right, Mr. Smith, you can go back to your previous assigned breakout room.
Your Honor, may we both be excused now that we've talked to our client and we're coming back on Tuesday?
Do you have your client back in the main room?
No, he's in jail.
No. He needs to come back to the main room. You can't leave him in the breakout room by himself.
Okay.
Thank you. All right, Elizabeth Russell.
Yes, Judge. After talking to my client, we do want to be set on the trial docket, please.
All right, to attorneys. This is nothing new for the 187th. I always tell you, do not leave your client in a breakout room by themselves if they are an inmate.
Judge, I asked him to come back. I thought he came with me. I didn't wait for him. I apologize.
Okay, everyone, before you leave breakout rooms, you need to make sure your client comes back to the main room. So Ms. Russell, if you can go get your client and have them come back to the main room, that will be appreciated.
Yes, Judge. Do we need to re-announce again?
Yes. All right, Scott McCrum on Rudy Martinez.
We conferred, Judge. I got an offer. It's the first time I've received an offer. It's not what we were looking at to get it done today. But I'm still hopeful that we can get something done. So I'd like if you would give me a plea deadline of maybe 30 days out.
All right, Ms. Ferguson on Rudy Martinez, can I have a 30-day reset, please, for a plea deadline date? All right, your plea deadline date is June 28th. And if you have nothing else with this, you and your client are excused.
Thank you, Judge.
You're welcome. Ron Zimmerman. Okay. Tony Hernandez.
Yes, Judge.
All right, you're off docket. I don't have whatever you're off docket for. It hasn't been given to me.
Okay, Judge, I can email it to you if that's easier.
All right, what I'll do is I'll see you to breakout room number 1. Could a clerk meet Mr. Hernandez to breakout room number 1, please? Dwayne Ferguson? Yes. It appears that you're driving. That's not allowed. This is the second time I've had to speak to you about that. I hope you're driving towards the 187 District Court because your Zoom privileges are now permanently revoked. They will not be given back to you. All right, Mick Aguilera, you are done with Mr. Garcia?
Yes, ma'am. I was contacting the court Norma trying to get the inmate brought back. I saw him stand up, take his headphones off and physically leave that room over at the jail.
All right, well then just let Ms. Ferguson know that he's done.
Oh, you wanted him back in the courtroom?
Yeah, I don't like, they're not to be allowed in the breakout room by themselves, because when they're there by themselves, the deputies either think that they're done and they remove them, and they get removed without knowing what their next date is.
Oh, I'm sorry.
It takes us a lot of time to come back to get them
I
back.
understand. Yeah, I saw him take the headphones off and leave the room physically. And that's what I was telling Norma in a text, but he knows to come back. He'll be brought back Tuesday, 4 p.m.
Okay, all right, thank you. All right.
Thank you.
Okay, all right, Nathaniel Navy.
Yes, Judge. I have Carlos Gonzalez, 2022 CR 3269. I received an offer from the state, discussed it with them, discussed with my client in a breakout room. If I could just get a reset to discuss the offer and confer with the state on that.
All right, do you have all the discovery?
I do, Judge.
All right, Ms. Ferguson, can I have a 30-day plea deadline date for Carlos Gonzalez, please?
Okay. I think that's 6/28.
Yes, 6/28.
Okay. And then one more issue, Judge, and this was just from speaking to my client now. He's currently on the Smart Start device. His suspension is over with, and he would be able to start driving a vehicle. So if we could, I was hoping to get him transferred back over to Interlock, because I know he needs to be on the Interlock if he is going to be driving. So could I just submit a motion to the court to amend him back to the Interlock device?
Yes.
Okay.
But
I'll
he
get
is not to be driving, of course.
No, I know.
Without
And
that.
I don't have any indication that he has been. But now that his license is, now that he's eligible, if I could submit that to the court and that way he can get an Interlock installed.
Yes.
Okay. Thank you, Judge.
You're welcome. All right, Norma, do we have the interpreter for George Sherman? Right now, I'm constantly speaking to myself today. Eduardo Jimenez, who do you have?
Yes, Judge, thank you. I have Roy Ferguson. It's CTD. I have put in motions for sanity and psych evaluations.
Your client is actually driving to the 187 District Court.
Oh, Your Honor, he lives in Houston, I believe.
That's not my problem. He should not be driving on Zoom screen. I've told him
Oh,
that
no,
several times before.
I agree with you. That's absolutely unacceptable. But I don't know that he'll make it by the time. I don't know how long the court will be in session, and he lives in Houston.
Well, since he was driving, in my understanding, it takes probably maybe 3 hours from Houston, depending on the traffic.
Okay.
And I'm usually here till 5, and we're going to have a jury out deliberating, so we may be here.
Okay, shall I check in a little bit later then, given the circumstances? All right, thank you, Judge.
You're welcome. Dale Hill, who's your client?
Daryl Moore, Your Honor. And I apologize, I was in jail court trying to.
That's okay. Is it criminal trial division or family violence?
A criminal trial.
All right, I'm going to send you to breakout room number 5.
Thank you.
You're welcome. All right, is there a prosecutor available for George Sherman?
Judge, I'm here. If you can walk me through it, I can be present for a plea.
I most certainly will.
Judge, if I may, these papers were in person.
No,
So they're
the state should, I mean, the clerk should have these papers, whether they were in person or not. So did you turn them in to the clerks?
yes,
Okay, then we should have it.
good.
What is your client's complete name?
Say again.
Your client's, just one second.
Angel Mejia Apolinar. And you need a cause number?
No, I have it. Just give me one moment. Mr. Ferguson, you were driving. I don't care that you are in Houston. You need to get thee to San Antonio, Texas, the 187 District Court, the 4th floor. I've spoken to you about driving and Zooming before. At one point you were driving and Zooming. No, you need to appear in court. Everyone, just give me a moment, please.
Angel? Just have him come in here.
Mr. Sherman, could you make sure that your client is on the language?
That he is what?
That he is on the language station?
I apologize. I don't know how to do that.
All right. So if you will go to the bottom, and he needs to do it on his computer.
Okay, Judge, let me get my secretary who speaks Spanish to do that for him on his computer.
No, you can just get someone who speaks English. Just turn it on Spanish.
On his computer?
Yes, he needs to be on Spanish channel.
Okay.
You good, Chica?
Elsa? Okay.
Norman, can you see if he can hear you?
It's been done, Judge.
And his name is Angel Apolinar.
Sí, la escucho bien.
All right, and everyone else, please make sure that you're on the English channel. The court is calling 2022 CR 1469, State of Texas versus Angel Mejia Apolinar. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
George Sherman on behalf of the defendant.
And are you Mr. Angel Apolinar?
Sí,
We have an interpreter here today. If you could raise your hand, please.
muchísimas gracias.
Do you solemnly swear and affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God? All right, and if you could state your name for the record, please.
Ángel Mejía Apolinar.
Mr. Sherman, do you speak Spanish?
I do not, Judge.
All right, were you able to
You'll need to
have
try.
the,
Judge, I can't hear Mr. Sherman.
all right, Mr. Sherman, you need to go on the English channel, please.
Okay, how do I do that? I have two computers going here.
All right, if you would look at the bottom of your screen.
Here it is. Okay. Can you hear me?
Yes.
Okay.
All right, Mr. Sherman, all of the documents are in English. Were you able to have these translated for your client in Spanish?
Yes, I was, Judge.
And Mr. Apolinar, all of the documents I'm reviewing with you are English. Were those interpreted for you in Spanish?
Sí. Sí.
All right, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Sí.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Apolinar, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Sí.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're proceeding on the indictment, the lesser included offense as driving while intoxicated as a Class B misdemeanor. Is that correct?
That's correct, Your Honor.
Any objections?
No objection, Your Honor.
Mr. Apolinar, did you review documents with your attorney entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions? Did you understand it and did you sign it in all the appropriate places?
Sí.
Did you understand your charge with the lesser included offense, or the state is proceeding on the lesser included offense of driving while intoxicated as a Class B misdemeanor? The range of punishment is anywhere up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Sí.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Sí.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Sí.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Sí.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 180 days in the Bexar County Jail and up to a $2,000 fine? Did you understand?
Sí.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Apolinar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No.
Are you satisfied with the way you've been represented?
Sí.
Are you a U.S. citizen?
Soy residente.
All right. Counsel, did you advise your client of the consequences of entering a plea of no contest in the application or guilty in the application of federal immigration law?
Yes, Your Honor, and I've received a Padilla letter from his attorney, and my client is well aware of the circumstances.
Right. Did the advice include possible consequences such as deportation, exclusion from admission to the United States, and the denial of naturalization?
Yes, Your Honor.
Do you believe your client understands the consequences of entering a plea bargain in this case?
I'm confident that he does understand.
And for the record, the court will note that in the court's file, there is a letter from attorney Roland Gutierrez, and it is a Padilla letter. Mr. Apolinar, were you advised of the consequences of pleading no contest or guilty in the application of immigration law as it relates to this case?
¿Me puede repetir esa pregunta?
Were you advised of the consequences of pleading no contest or guilty in the application of federal immigration law to this case?
Sí, lo entiendo.
And did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Sí, lo entiendo.
And do you understand the consequences of entering a plea today?
Sí,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargain agreement, state is proceeding on the lesser included offense of a Class B misdemeanor DWI. There's a $1,000 fine, and the state recommends deferred adjudication. Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Mr. Apolinar, did you understand that to be the plea bargain agreement?
sí,
Did you understand by signing the paragraph, the waiver appeal paragraph, you are waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
sí, lo entiendo.
Counsel, have there been any such motions?
There were none, Your Honor.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, DWI intervention, VIP live, and admission interlock for the full term. Did you understand that to be the plea bargain agreement? I'm sorry, did you understand that that's outside the plea bargain agreement, Mr. Polinar? You can take these back.
Sí,
Defense, I'm sorry. Just one moment, there's someone else back here. All right, then, Mr. Polinar, to the lesser included offense of Class B misdemeanor DWI, how do you plead? Guilty, not guilty, or no contest?
Lo que diga mi abogado es bien para mí.
The papers, Judge, indicate a no contest plea.
All right, Mr. Apolinar, are you wishing to enter a plea to DWI as a Class B misdemeanor?
Sí, declaro.
Your attorney is stating that you are pleading no contest. Are you pleading no contest?
Sí, no me pongo.
State any evidence to support the defendant's plea.
I'm sorry, Your Honor. At this time, state offer states exhibit number 1 and its attachments.
All right. Any objections?
No objection, Judge.
Mr. Polinar, did you review a document with your attorney entitled waiver of consent to stipulation of testimony and stipulations? Did you understand it and did you sign it in all the appropriate places?
Sí,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
sí,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
sí, lo entiendo.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I just ask that the court go along with the plea bargain and as far as the conditions, that the court do 1 year ignition interlock in this case and 2 years probation.
All right, Mr. Apolinar, do you have any children?
Sí. Sí, tengo dos.
What do you do for a living?
Yo trabajo mantenimiento de los apartamentos.
All right, this is the court's ruling. 2 years deferred adjudication, ignition interlock for the full term, 120 hours of community service restitution. The court will deduct 40 of those hours if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. $1,000 fine to be probated, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be parenting classes. The court will waive the remaining of your community service hours once you complete parenting classes, DWI intervention, VIP live, field visits, regular once per month, regular reporting by Zoom or in person, and regular UAs. Mr. Apolinar, did you review the document entitled Trial Court Certification of the Defendant's Rights to Appeal? Did you understand that and did you sign it?
Sí.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Sí, lo entiendo.
All right, good luck to you, Mr. Apolinar. I'm going to send you to a breakout room, probation. I'm going to send in a breakout room number 1. Ms. Nero, could you go to number 1 to interpret, please? And Mr. Sherman, you can go to number 1 or either you can be excused.
Thank you, Judge.
You're welcome.
Está bien, muchísimas gracias.
All right, George Sherman, I'm just trying to find you on the Zoom screen. Just 1 second. There we go. Hopefully someone can help him go to the breakout room. All right, anyone else ready?
Yes, Your Honor, you asked me to come back to the main session after I conferred with Mr. Christian Smith.
Okay. Just 1 moment. All right, Norman, Mr. Smith is excused.
Está.
All right, he's 17F, Norma. And thank you, Mr. Garcia, you're excused.
Thank you, Your Honor.
George's for breakout room. All right, Stephen Harris, who do you have?
Good afternoon, Your Honor. I have Sierra Smith. I just got logged on. I was in the parole hearing, so I apologize for my lateness. I was just told that she's been told she has to come in physically today.
Yes, do you have, is she criminal trial division or family violence?
She's trial division, Your Honor.
Okay, thank you. I'm gonna send you to breakout room number 3.
Okay.
John Kuntz, I'm gonna send you to breakout room number 4.
Oh, no, Judge, I just need to report back to, I've already met with the prosecutor.
You're like,
and
don't send me back, no.
Yeah, don't send me nowhere.
What is happening with Jackson?
Judge, we're gonna have to set this for a contested MTR.
All right, Ms. Ferguson, can you set this for a contested MTR as quickly as possible, please?
That would be great.
All right, we'll be back on June 13th at 2 p.m.
Sounds great, Judge. Thank you very much.
You're welcome.
Have a good day.
You too.
Mr. Jackson is in here, or did you just?
Oh, he's been removed.
Okay.
All right, thank you for bringing him back, though. That's appreciated.
You're very welcome, Judge. Have a great afternoon. Take
All
care.
right, you too.
Thank you.
Brenda, did you see Mr. Jackson on? Gotcha. Wow, I come back, there are a lot of hands raised. All right, Mr. Gibbia, who do you have?
Good afternoon, Judge. Nice to see you. I have Migdalia Salazar. We were here for a plea bargain offer, which we have now received from Ms. Hayden. We would like to be moved to a plea deadline setting so that I can review it with my client.
All right, Ms. Ferguson, can you call Ms. Salazar back in 2 weeks, please, for a plea deadline? All right, we're coming back on June 14th.
Thank you, Judge. I hope you have a wonderful day.
All right, thank you. You two have a good one.
Thank you.
All right, Andrew Froelich.
Yeah, I just need a breakout room with my client so I can go over paperwork.
All right, Mr. Navarro, I'm going to send you to breakout room number 2. And Mr. Froelich, what previous breakout room were you in?
6, Your Honor.
All right, I'll send you to number 2.
Thank you, Your Honor.
Michael.
All right, Mr. Leos. Manuel Leos. All right, Jesus Perez, can you unmute for me, please?
Yes, ma'am.
All right, Mr. Perez, you're here for a compliance hearing. Do you know why you're here?
No, ma'am.
All right, there appears to be an issue about you not signing documents.
I signed all the documents I needed to sign, ma'am.
All right, they're saying that you haven't signed something. So here, and that you're refusing to sign. So here's the thing. I'm going to send you to a breakout room.
Yes,
And
ma'am.
if you do not want to sign the documents, you don't have to sign the documents. I'm not going to force you to sign them. What will end up happening is a motion to revoke will be filed. Do you understand?
Yes, ma'am. But I have, okay.
That's the report I'm receiving, Mr. Perez.
Who'd you receive that from? Because I saw my probation officer and my probation officer came and saw me on Zoom and I signed all the documents I needed to sign. I also signed all the documents I needed to sign with the lawyer, James Mayrat. I also signed all the documents. I didn't get a TAP eval. I didn't go, I have now received my TAP. I came to a TAP evaluation, but the TAP evaluation, she said they were going to reschedule me. I have no problem signing any paperwork.
All right, so make sure you sign it because they're saying that you are not signing paperwork.
Well, I was also told that when I went to court that if I was approved for drug court, that I would go
Yes.
ahead and go into drug court and not have to go to ISF.
Yes, that's
And-
true.
And then now all of a sudden my probation officer said that I have no choice but to go to ISF instead of drug court. I don't understand
Now,
that.
here's the thing. If drug court doesn't accept you, then you're not going to drug court. If drug court has a waiting list, you're not going to drug court. You will be going into ISF if you're not accepted to drug court, okay?
Yes, ma'am.
All right, so there is no, you're gonna remain in custody. To probation, Mr. Jesus Perez, he's to remain in custody until he's accepted to felony drug court or either ISF.
I believe if this is the case that was here last time, was this case here last week?
Yes, ma'am.
Okay, the deal with his case is that he has a pending case in Polk County, apparently. And so they will not accept him in the drug court with any other cases out of the county. So he's not going to be accepted into that case. I do not know, I don't see an actual hold on him for the jail. So he might be on bond on that Polk County. So there shouldn't be any issues with him being transferred to the state ISF facility.
All right, so Mr. Perez, you'll be going to ISF.
Yes, ma'am.
All right, thank you, Mr. Perez.
Thank you.
Yes, yes.
And I need to sign the paperwork, correct?
Miss Saldana, has he signed paperwork or no?
If we could hold on to him, I haven't reviewed that part. Let me look into that real quick.
All right, Mr. Perez, just give us a moment.
Yes,
All
ma'am.
right, the other person is Terrence Scott. Mr. Scott, you're here for compliance.
I don't understand what compliance. at
Oh,
all.
there's some issues with your case.
But they're supposed to work, I mean, I'll go to UAs every day.
So we were trying to check the status of his felony drug court probation.
I don't know, man, I'm sorry, to my temper, but it's
Drug
like, I
court.
feel like hearing.
So it was the withdrawal referral from felony drug court, and he was supposed to continue to ISF because of the nature of his charge, and that he doesn't meet felony drug court criteria.
Yes, Your Honor. So the status as of 5/10, he was cleared and scheduled for a state ISF pickup, but right now there's a wait time for placement and it's 28 to 42 days.
All right, then he'll have to wait till placement. All right, so Mr. Scott, we're waiting for you to go to ISF. You're not eligible for felony drug court.
Yes, ma'am. We said that back in March or February, March. They said I wasn't able to go to drug court and I was going to state ISF. And
Yes,
I
so-
thought I've been waiting since March to go to state ISF.
So here's the thing, it was withdrawn, your application for felony drug court because you were to be released to state ISF and you were to be released to state ISF because you were determined not to be qualified for felony drug court. So we're gonna get you there as quickly as possible. Mr. Leos? Manuel Leos.
Yes, ma'am.
All right,
Can you
Mr.
hear me?
Leos, yes, Mr. Leos, I can hear you. All right, Mr. Leos, I understand that you have different issues, but here's the problem. Either you're on probation or you're not on probation. If you're not on probation, then either the state or somebody's going to want to file something or your attorney's going to want to file something to terminate your probation, or either you're going to have to do probation.
Or what?
Or either you're going to have to do probation. Your problem is you continue to have, I know you're doing dialysis. I know all of this stuff is going on with you, but you're not doing anything for probation. And you're requesting for removal of the device. The court cannot remove the device because you're on probation for DWI.
I don't even drive no more.
You know, that's what was.
My vision is bad. I mean, I wouldn't even try to attempt to drive.
Here's the thing. I understand your vision is bad. I understand the whole thing with the DWI, but the court's problem is that I'm sure your vision was bad when you picked up the DWI.
Not as bad as it is now.
Yeah, but I mean, you were driving. I can't have you driving. You have cars at your home, so that's not going to happen. So the ignition interlock is going to have to remain. Do you understand?
I don't even have that. I got the home device.
Yeah, well, you're remaining on your device. All right, I'm sending him to breakout room number 1. And Mr. Scott, I'm sending you to number 1. And Mr. Perez, if you go to number 1 probation, we'll meet you there. Mr. Leos, you'll go to number 1 probation, we'll meet you there. And who is here on Kirby Monique?
Ron Zimmerman, Judge, I'm here.
All right, just give me one moment. And to probation, I'm sorry, not probation, to a state's attorney, can you please send me the discovery on Monique Kirby? Because the court doesn't have that.
Judge, if I may, Brittany Sparks sent that to me. I signed it and my screen says that it's been sent. I've got a big red bar saying it's been signed, but your clerk could not locate it. And he thought maybe it was in your possession.
No, it is not. Who is the prosecutor on Monique Kirby, please?
That would be Brittany Sparks, at least the one that I've been dealing with, Judge.
I understand that, Mr. Zimmer, when I say who is the prosecutor,
right,
that's because I'm waiting on a prosecutor.
Right, I understand.
Judge, I'm here in the courtroom. I can do it, and I'm going to send you discovery right now.
All right, thank you. All right, the court is calling 2021 CR 6503, State of Texas versus Monique Kirby. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Ron Zimmerman for Ms. Kirby.
And are you Ms. Kirby?
Yes, ma'am.
We're proceeding by video. Any objection from the state or the defense?
No objection.
No objection, Your Honor.
Ms. Kirby, did you review the document entitled Defendant's Consent to Appear by Video with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, have you received all the discovery in this case and did you review it with your client?
Yes, I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Kirby, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Ms. Kirby, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft, 2,500 to 30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state and the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, she has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe so, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Kirby, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,000 fine to be probated. State recommends deferred adjudication. There's to be restitution of $3,750. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Motions filed, but none ruled on, Judge.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours community service restitution, no contact with any Circle K and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Judge. State offer states Exhibit 1 and all attachments.
No objection, Your Honor.
Ms. Kirby, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Ms. Kirby understands that she made a mistake. She broke the law, and she is before this court to accept responsibility as such, Your Honor. I believe that she has a fairly clean record. There is no other indication in Bexar County that she has committed any other offense other than a traffic offense in Bexar County, Judge. And we would request from the court that the court does grant deferred adjudication probation for Ms. Kirby.
All right, Ms. Kirby, are you still with your husband?
Yes, ma'am.
Did he ever tell you that you should not be doing this?
No, ma'am.
So you need to ask yourself whether or not he has your best interests at heart. Do you understand?
Yes, ma'am.
Do you have any children?
Yes, ma'am.
What are their ages?
Including my stepkids, 20, 18, 9, 4, 9, 5, 2, and a month old.
All right. And are they with you?
Yes, ma'am. Well, the 20-year-old doesn't.
All right. The minor children, are they with you?
Yes, ma'am.
Are you currently employed?
No, ma'am.
Is your husband employed?
No, ma'am.
How are you all supporting yourself and children?
My husband draws disability.
Why is he drawing disability?
He's been disabled since the age of 15.
I mean, what's his disability?
He was shot in the head. He has sickle cell. I think he's drawn the disability for memory problems, being shot in the head.
All right. And is this restitution to Circle K or is it to Texas Lotto for taking lotto tickets without paying for them?
It's to Circle K, Judge.
All right. So there's a restitution of $3,750 to Circle K. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes. The remaining of the community service hours will be waived once you complete parenting classes. There's to be no contact with any Circle K. Don't buy any lottery tickets or take any lottery tickets. CATS 1 and CATS 2. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. And honestly, I'm going to remove CATS 1 and CATS 2. Here's the thing, don't steal. That's my lecture for you today. If it doesn't belong to you, don't take it because that's stealing. That's not a mistake. Those are choices. Do you understand? And
Yes,
the only
ma'am.
reason why I'm removing cats 1 and cats 2 is because you have children that my grandmother would say were stair steppers, which is like you're going down the stair. There's no gap in between. Do you understand?
Yes, ma'am.
And anybody who encourages you to steal or take things is not your friend and doesn't have your best interest in heart. Do you understand?
Yes, ma'am.
So there should be no cats 1 and cats 2. I just gave her the don't steal. I just gave her the course. Proof of employment within 30 days, no employment as a home health care provider with minors. There's to be regular reporting by Zoom or in person. If you can't report by Zoom, you need to do it in person. I'm going to want field visits 2 times per month. Regular UAs. Is there anything else you need, Ms. Kirby, to be successful in life and not steal?
No, ma'am. I did have a question. The proof of employment.
Yes.
That means I have to get a new job within 30 days.
Yes, or either show proof that you've been looking. You understand? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, Miss Kirby. I know sometimes things are maybe hard on people, finances, and you want to take the easy road out, or maybe you think it's easy. Maybe you think, hey, I get a lottery ticket, I win $2 million. And let me just tell you, if you'd have won $2 million on a scratch off, guess what? They would have found out that that ticket wasn't paid for and you wouldn't have gotten the $2 million. And when you do things like this, it creates a snowball effect. So now, instead of just having a bill that maybe you couldn't pay, now you're on probation. And this is considered a crime of moral turpitude. Do you understand?
Yes, ma'am.
All right, good luck to you. I'm going to send you to a breakout room. Probation will go over conditions with you. I'm going to send you to breakout room number 1.
Your Honor,
Yes.
may I get clarification? How many years did Ms. Kirby get?
She is on deferred adjudication for 3 years.
Yes, Your Honor. Thank you.
And Ms. Kirby, if you complete everything sooner than that, you can ask for early termination.
Yes, ma'am.
All right, I'm going to send you to breakout room number 1. All right, Tony Hernandez. Oh, I come back and the screen is filled with people. Albert Van Cleve. I'm going to send you to breakout room number 6.
Okay, Your Honor. Thank you.
You're welcome. Alice Warburton.
Hello, Judge. The state has informed me that they have some of the discovery we were waiting on last time and that it is at the 5th floor. There is some inconsistencies as to whether or not there are additional CPS records. They're going to check into that. The records that they do have for me are going to enable my investigator to start doing some much needed looking into things. And so we've made some progress. I still do not have an offer, which is to be expected on a 3rd setting with this much work to do. So we just asked for a regular reset.
Okay, the court doesn't expect that on the 3rd setting. Ms. Ferguson, give Ms. Warburton on Elizondo, give her a month reset. And that's the last setting, both sides for discovery. And if this discovery is not here at trial time, then we can take that issue up when we approach it. So we're going to come back on June 27th. On June 27th, I'm going to expect the state to tender an offer. And we will go from there.
Okay, and the June 27th, Judge, will that be at 9 a.m. or at 1:30?
You'll need to speak with the coordinator, but I want to say it's 9 a.m.
Okay, is there any way that we could change it from the 27th to the 28th, Judge?
Why?
Because I'm completely free that day and do not have to go out of county. And so whatever time the court chose on the 28th wouldn't matter to me. I'd be available to you no matter what. Whereas on the 27th, I might have some difficulties.
That's okay. We'll wait for you. We're
Okay,
here from 9 to 5.
okay, we'll see you on the 27th.
All right.
Okay, Mr. Elizondo, you're excused. Come back on the 27th. Thank you.
All right. You're welcome. Dale Hill?
And I'm so sorry, Judge. And it will be Zoom?
No, it will not.
Okay, Mr. Elizondo in person, and I'll let you know if it's 9 or 1:30.
Thank you. Dale Hill?
Hi, Judge. Could I I need to speak with the prosecutor. Criminal trial.
All right. If you'll go back to breakout room number 5, they'll meet you there. Kyle Ernst?
Yes, Judge. Can I be transferred to one of the prosecutors in the criminal trial division?
All right. I'll send you to number 7.
Thank you, Judge.
Andrew Froelich?
We're ready for a plea on Mr. Navarro.
All right. As soon as I have the paperwork, I'll take that up. Luis Martinez?
I need to confer, Judge.
All right. I will send you to number 8.
Thank you, Your Honor.
You're welcome.
Judge, do you have the plea paperwork for Mr. Navarro? I think you
No, I
should.
do not have it.
Oh, my apologies.
No problem. Joseph Acevedo?
Yes, Your Honor. May I confer with Brittany, please?
Who's your client?
Client is Mr. Whitley.
All right, I'm going to send you to number 9.
Thank you.
Cornelius Cox?
Hi, Judge. I'll get him for you right now.
All right, who does he have, Angel?
Manti Salazar, man.
Do you know if it's criminal trial division or family violence?
I do not know. Let me get him.
All right, what is he charged with, Angel?
I believe it's family violence.
Okay.
Family violence, man.
All right, thank you. I'm going to send you to breakout room number 13. James Marriott?
Yeah, good afternoon, Your Honor. I have a person in custody in today's afternoon docket. His name
What is his name?
Taylor.
Criminal trial division or family violence?
Trial division.
All right, I'm sending you to number 18.
Thank you.
You're welcome. And to the clerks, you should have some paperwork.
Thank you.
So what I'm going to do is I'm going to send you all to the waiting room. Mr. Navy, on your document, the ignition interlock, the court has already signed that, but if this is something new off docket, then we'll take that up after we take the punishment from the jury.
Okay, yes, Judge. There is something new that I need to discuss with family violence if I could be placed into a breakout room with them.
All right, so what I'm gonna have to do is I'm gonna have to put you all in the waiting room unless you all make the promise that you will not leave the breakout room until the court, which is me, remove you from the breakout room.
Okay, so I just go to a breakout room and just wait there?
Yes.
That sounds good, Judge.
All right, I'll send you to number 16.
Thank you.
Everyone else will be placed in the waiting room. And to the clerks, if anyone from the waiting room is needed in the breakout room, just quickly remove them and place them in a breakout room.
Yes, ma'am.
All right, thank you. All right, so is
They went inside the holdover area to talk to their client.
what are they speaking about, changing election or something?
That's a possibility, Judge.
Okay,
That would make this all go faster.
okay. Yep, that's the lotion bottle.
And all the jurors have been.
Okay. Even.
Barely awake, but she's there.
The other guy, good fellow.
Yes, Your Honor.
Okay. Hey, it's a Monday on a Thursday, but it's a happy Thursday. All right, Mr. Rodriguez, everyone just give us a moment. We're handling jury issues here. Mr. Van Cleve?
Yes, Your Honor.
Yes, what is happening with Mr. Marshall?
Your Honor, we're basically ready to go on the trial.
All right.
Want to be put on the trial docket. We do a couple more documents we need from the DA's office on the discovery, but I think we got that in hand.
All right, just give me a moment. All right.
And I've been told if I read it.
Okay. All right. Just one moment, Mr. Marshall. All right, and to the court. I don't have a video. Right. All right, we're on the record in 2020 CR 11338. All right, the court is in receipt of the change of the election of punishment to in this cause number. And that has been found stamped in mark. And Mr. Contreras, you have agreed to change your election of punishment to the court. And my understanding, there is no objection from the state. Is that correct, state?
That's correct, Judge.
Right. Then this is the punishment phase of the trial. Defense, are you ready to proceed with punishment?
Yes, Your Honor.
State, are you ready to proceed with punishment?
We are, Judge.
All right, state, any evidence to offer in punishment?
Yes, Judge. State would offer States Exhibits 12 and 13, which I previously shot defense, but they are two felony judgments for Mr. Contreras that are part of the enhancement allegation.
All right, any objections to the state's exhibits?
No objection, Your Honor. We've reviewed those judgments. We've discussed the matter with my client. We have no objections to the state's judgments.
All right, then state's exhibits 12 and 13 will be accepted into evidence. And defense, does your client stipulate that these judgments are judgments of his in the, just one moment, let me grab his file. Is your client stipulating to the repeater enhancement paragraph?
Yes, Your Honor.
All right, Mr. Contreras. How do you plead to the repeat enhancement allegation paragraph? It states, and it is further presented in and to said court that before the commission of offense alleged above on the 7th day of December AD 2005 and cause number 2004 CR 3635W in Bexar County, Texas, the defendant was convicted of the felony of burglary of habitation force. How do you plead to that? True or not true?
That's true.
And how do you plead to state's exhibit number 13 that was admitted? It's a judgment. The cause number in that judgment is 2017 CR 2769W. The offense is possession of a controlled substance, polluted group 1 gram to 4 gram. The sentencing date on this case is March 16, 2017. How do you plead to that? True or not true?
True, Your Honor.
All right, is there any evidence from the defense?
Your Honor, we're not calling anyone. If you would like us to give a brief argument, we can, Judge.
All right, state, what are you requesting?
Judge, I believe based on the 2 prior enhancements and the notice that we gave the court, his minimum is 25 years, and we're asking for 25 years, which is the minimum.
All right. All right, Mr. Contreras, that is the minimum sentence that the court can give you. Do you understand?
I understand.
All right. Defense?
Your Honor, I'm also requesting the minimum of 25 in this case.
All right, then Mr. Contreras, the court will sentence you to 25 years in the prison, give you credit for any time served, and there's an affirmative finding of deadly weapon. Mr. Contreras, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
I signed it.
I'm sorry?
I signed it. I didn't reviewed it.
Okay. All right, Mr. Contreras, you do have a limited right to appeal. Well, not a limited right to appeal. You do have a right to appeal because this was a jury trial. Do you understand?
I understand.
If you cannot afford to have an appellate, hire an appellate attorney, or retain an appellate attorney, one will be appointed for you. Do you understand?
I understand.
Defense, do you wish to remain on as appellate attorneys?
Your Honor, I've discussed that with my client. I am going to assist in filing the notice of appeal, but I think it would be in his best interest if a separate attorney who did not handle this phase would handle it. So that I will continue to.
All right. So, Mr. Contreras, what will happen in the next phase of the process is an attorney will file, your attorney will file the notice of appeal, and then an appellate attorney will be appointed to represent you. Do you understand?
I understand.
All right. Do you have any questions about anything?
Time on it, really?
I'm sorry?
Yeah, how long is that?
25 years with an affirmative, we can go off the record, Brenna. With an affirmative finding of deadly weapon, I'm sure your attorney will explain to you that you have to do half the time before you're eligible for parole.
Judge, I'm sorry to interrupt. I believe what he was referring to is the time frame on the appellate process.
That's what you're asking?
Yes, ma'am. That's what I was asking. I was like, getting appointed appeal attorney that you're telling me how long will that?
All right, so this is what will happen. As soon as your attorney files a notice of appeal, I will be informed of it, and an appellate attorney will be appointed. And just one moment, Ms. Ferguson, could you please review and see who is on the appellate list? And what I will do before he leaves, what I'll do is I'll make sure that we have an attorney on the appellate will for you before you leave the courtroom today, okay?
Yes, ma'am.
All right, defense will have that attorney's name today.
Okay.
So just remain in the courtroom and we'll make that happen. And defense. You want. All right, everyone, we're going to take a short break. I need to release the jury in this cause. So everyone just be patient and I will be right back. T. Anthony Chokansky.
Yes, ma'am.
All right, who's your attorney?
Martin Guetta.
All right, I see him zooming in. Who's the prosecutor? Who's the prosecutor on Kochansky?
Your Honor, I've conferred with Ryan Groomer this morning, although I'd also talked to Marcus, but I believe I'm not sure if he's here today.
All right, let me find I'm gonna find a prosecutor, just one moment. Okay, just give me one moment. I'm trying to find a prosecutor. I just knocked on one of the breakout room doors, so we'll see if I get someone. Michael Villarreal.
Yes, Judge.
Hi, I knocked on the door.
And I came right as soon as you knocked, Judge.
You answered. I appreciate that. Are you available to do a plea?
Yes, Judge.
All right, and I'll walk you through it.
Okay.
All right, the court is calling 2021 CR 9763A, State of Texas versus Anthony Kochansky. Can I have parties announced for the record, please, for the state?
Michael Villarreal for the state.
For the defense?
Martin Guerra, attorney for Anthony Kochansky.
And are you Anthony Kochansky?
Yes, I am, ma'am.
All right, we're proceeding by video due to the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Kochansky, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you counsel's discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Kochansky, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on the lesser included offense of theft from a person. Is that correct?
Yes, Your Honor.
All right, Mr. Kochansky, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I did.
All right, did you understand the state is proceeding on the lesser included offense of theft from person as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this cause?
Yes, ma'am.
Off the record for a moment. Counsel? Defense? His attorney is going to be Patrick Montgomery. If you'll speak to Ms. Ferguson, she'll give you the information, the contact information for Mr. Montgomery to give to your client. All right, back on the record. Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Kochansky, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I have.
Are you a U.S. citizen?
Yes, yes, ma'am, I have.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of theft from a person. They're asking that your punishment be assessed to 302 days in the Bexar County Jail under 12.44 of the Penal Code, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am, I have.
Counsel, have there been any such motions?
No, Your Honor.
Into the offense of theft from a person, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the plea?
Yes, Your Honor. At this time, state offers State's Exhibit number 1 and its attachments.
No objections, Your Honor.
Mr. Kachonsky, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I have, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after viewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty of theft of person. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, aside from the fact that he accepts responsibility, he's had 302 days in Bexar County Jail, which has had an impact on him. He's ready to go forth and do well. Respectfully, we ask that you follow the plea bargain agreement.
All right, then the court will follow your agreement, find you guilty of theft from a person, sentence you to 302 days in the Bexar County Jail under 12.44. Give you credit for any time served. The court will note that the judgment is satisfied. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I have.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or an ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Kochanski, good luck to you. I can tell you, you're not living up to your nickname, which I read in the police report, it was Buddha. I've never heard of Buddha going around committing thefts of person. If you want something, you need to work to get it. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Mr.
Thank you, Your Honor.
You're welcome. Have a great rest of your day.
Thank you. You too, ma'am.
Thank
Good
you.
luck, Anthony.
Thank you,
Number
sir.
17B can go back. All right, Tony Hernandez.
Yes, Judge, can you hear me?
Yes, just give me a moment.
Surely, certainly.
Thanks, Judge.
All right, you're welcome. Have a great rest of your day.
There's a lot of stuff in here, guys. You're gonna have to sit around it for a
I
minute.
think took the file on Contreras. Can you have him bring that back, please? Thank you. All right, yes, Mr. Tony Hernandez.
Get into. Yes, Judge, can you hear me okay? Judge,
Yes, I can hear you.
on Rudy Xavier Rodriguez, we filed a motion requesting the court to allow him to attend the funeral. His cousin passed away recently, and there's services tonight, or actually from 3 o'clock until I think 8 tonight is the visitation, and then tomorrow is the funeral, tomorrow morning. And it's set out, I think, in detail in our motion there. He's on monitor right now, Judge. He's still unindicted.
All right, so I have a time on here for mass, but I have no ending date. I mean, so no
After the
ending
mass,
time.
Judge, after the mass, Judge, they're going back to the funeral home, and then I think they're leaving for the cemetery at 1:45. The services were put together kind of rushed. I think they just started working on them on Monday.
Okay, so what I'm reading in your motion is that mass will be held on Friday, starting at 9 a.m., then 10
Correct.
a.m., then 2:30, followed by late lunch. But I don't have
Correct.
an ending time.
Oh, I'm sorry, Judge. I would imagine that the lunch will last a couple hours, and that'd be about it. So I would think 4:30.
So, okay. All right, State, do you have any objection? State, it's on Rudy Xavier Rodriguez, 9 bag number 582413.
And Judge, I think if Marcus is available, I think it was his case. And I emailed him a copy of the paperwork earlier today.
All right, what time are you saying he's finishing with the lunch? I'm sorry, you said maybe 4?
I would say 4:30, Judge. You know, those types of luncheons usually last a couple hours, 2-3 hours.
All right, he's gonna have to return by 5:30 p.m. So he needs to be at his designated location by 5:30 p.m.
That should be fine, Judge.
All right, thank you.
And Judge, is he allowed to go to the services, the visitation tonight?
Yes, I signed the visitation.
Oh, perfect. Thank you very much, Judge. I appreciate that.
All right, you're welcome.
And Judge, I'm sorry, one last question. I'm not sure how pretrial will be notified at this hour.
Oh, it's gonna be placed in the system.
Okay. Then that'll work. I appreciate it. Just thank you very much.
All right, you're
And
welcome.
Rudy's online, Judge, so he can, if he can hear me, if he'll just log off and call me.
All right, thank you.
Okay. Thank you, Judge.
And Mr. Rodriguez, you need to follow those rules.
Yes, ma'am.
Thank you. All right, Albert Van Cleve on Marshall.
Yes, Your Honor, we're announcing that we're ready to be put on the trial docket.
All right, Ms. Ferguson on Mr. Marshall. This is a first setting. Did you receive an offer and have you received all the discovery, Mr. Van Cleve?
We have received an offer and we're missing a couple of pieces of discovery at this point. I think we can make arrangements to get those from the DA, okay?
All right, what discovery are you, is outstanding?
I'm not exactly sure, Your Honor. There were a couple items I was told were still outstanding.
All right,
They were gonna get to us.
prosecutor, do you know what discovery is outstanding on Mr. Marshall?
Judge, is this CTD?
Yes.
Okay, let me check.
All right, it's 2020 CR 2764. And Angela Blake, on your client, is that a plea?
Yes, Your Honor.
Do you have all the paperwork?
I have both paperwork done for the state. I'm just waiting on appeal paperwork from Norma. And my client is in the courtroom. I believe the clerk said you had signed one document from the state, but not the second one.
I've signed everything that's in my box, so.
Okay. That was just a
All right,
couple
thank you.
minutes ago. So, okay. Thanks, Judge.
Sure, no problem.
Judge, this is Brittany. If I can just go talk to the defense attorney on that case real quick, please.
Yes. All right, and that's Mr. Albert Van Cleve, so you can send him to whichever breakout room, Brittany, that's available.
Thank you, Your Honor.
You're welcome. Kyle Ernst.
Yes, Judge. I was in the breakout room and no one ever came into the breakout room.
Oh,
So,
they will make their way there now. They have been in a jury trial.
okay.
So I'm going to put you in number 10 and someone will meet you there.
Okay, thank you.
You're welcome.
And Judge, I actually was in a breakout room and spoke with my ADA.
Yes.
And so we were requesting a pass. The only thing that's missing is you've signed an order to release the CPS records. I need to actually physically come and view those in person. And at that point, we intend on entering into an open plea.
All right. And when is that going to be accomplished?
I'd like at least 30 days if the court will allow.
All right. And you said that it's going to be an open plea?
I believe so, Judge.
All right, Ms. Ferguson, can you reset this in 30 days for disposition? It's Kesey. All right, we're going to come back on June 27th.
Thank you, Judge.
You're welcome. All right, Mr. Van Cleve.
Yes, Your Honor, the district attorney said they'd have it ready for us to pick up.
All right. And when will that be ready?
Judge, we have a note in our file that was left down on the 4th floor on January 4th of this year. I told defense counsel if it's no longer there to let us know and we'll recreate a new one.
All right, thank you. Ms. Ferguson, on Van Cleve, can you give me a 30-day reset for our jury for plea deadline? And it's his client is Mr. Marshall. All right, we're going to come back on June 28th, and that's going to be your plea deadline date. And then Mr. Marshall and Mr. Cleve, we will do a quick turnaround for jury trial if that's what you're asking for.
Thank you, Your Honor.
All right, you're welcome. You're excused.
Thank you.
Number 17E can go back. And everyone, just give me one moment. All right, Mr. Navy and then Mr. Cox. Mr. Navy?
Judge, actually, this case is going to be handled by a special unit in the DA's office. And so Mr. Villarreal was seeing if they were available to come really quick.
Okay.
And Judge, I just got a hold of David Lunan and he is going to be logging on. I'm going to send him the link.
All right, thank you.
Thank you.
Mr. Cox?
Yes, ma'am. Judge, on the Matthew Salazar,
Yes.
the Shane and I, we talked, and what they would like to do is there's a new case that's that has not been indicted yet. She would like to have an opportunity to review that case So to see whether we can work out something on the,
All right, and what is the new case?
the new case is aggravated assault.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Salazar?
Thank you, Judge.
You're welcome. It's gonna be June 28th.
June 28th. All right, thank you.
You're welcome. Bye-bye.
All right.
Mr. Salazar, you can log on.
Thank you very much, ma'am.
You're welcome. Dale Hill?
Judge, I've been waiting in my room. I never did get a prosecutor. I think I might have forgotten.
Oh, no, they were in a jury trial, but they're out now. So someone will meet you in breakout room number 4. I'll move you up.
Okay, thanks.
You're welcome. Joseph Acevedo?
Judge, I was trying to get into a room again with Brittany. I was on at my office, but trying to get back on with her.
All right, who's your client?
Whitley?
All right, I'm gonna send you to breakout room number 5.
Thank you.
You're welcome.
Excuse me, ma'am. I was making
Just one-
sure I'm able
Just
to
one
read.
moment. All right, yes, Mr. Kesey, who was your attorney?
Christopher Lewis.
Yes, you've been excused.
Okay, thank you, ma'am. Have a
You're
blessed day.
welcome. Natasha Torres? Natasha Torres. All right, and but good now, you're in court. Yes.
I came to check on the motion I filed with Mr. Witron. I'm still doing the document.
Yes. Let me see.
That's my copy. It's original.
Okay, no problem. All right, just do me a favor and
Sure.
have them bring the one that I have. All right.
All right, I'll do that.
Okay, thank you.
Thank you, Judge.
You're welcome. Yes, Victor Perez.
Yes, ma'am. I'm here with Miss Natasha Torres.
All right, I'm just waiting for Miss Torres. Yes, Miss Torres.
I'm here, Your Honor.
All right, what is happening with Mr. Perez?
Your Honor, I spoke with Miss Michelle Hayden earlier. She mentioned that there was an offer and then I proposed a counter offer. She mentioned she would need not more than 2 weeks to reach out to the witness to see how she's going to respond to the counter we proposed.
All right, Miss Ferguson, could you recall Mr. Victor Perez in 2 weeks, please? All right, that's going to be June 14th.
Yes, Your Honor.
All right, and then your other client, Mr. Perez, you're excused.
Thank you, ma'am.
You're welcome. All right, and then your other client is Byers.
Yes, Your Honor, I'm with Mr. Byers in a breakout room. We have paperwork. I was just waiting on a brief response in reference to one of the conditions, but other than that, we'll be ready in the next few minutes.
All right, thank you.
Natasha, are you waiting a response from Michelle?
Yes.
Can you send me that? Michelle is currently unavailable.
Sure.
All right, and then Stephen Harris.
Hi, Judge, I'm back. I just spoke with 88 Brittany Sparks. We applied for the PTD program, Judge. Brittany checked on it. They do have it. They are taking a look at it. They just haven't given us an answer yet, but it's been processed and Brittany has confirmed that.
All right, Ms. Ferguson, can I have a 30-day reset on Ms. Smith for a PTD update? And Mr. Moore, you need to turn on the light. All right, but don't turn it on if you're in the witness protection program. Otherwise, you need to turn it on. Moselle Moore, we cannot see you. All right, the next court date is going to be June 30th. Sierra Smith?
Yes, Judge.
Now, I understand. You need to make sure that next time you're on Zoom, that you're dressed appropriately, okay? All right. They're going to give you a reset form for June 30th. So just wait in the courtroom and they'll give you that setting.
May I be excused, Judge?
Yes.
Thank you.
All right, Dale Hill. You're on mute.
Okay, how about now? Do you hear me,
Yes.
Judge?
Yes, I can.
I did have a question, Judge. Today was, I guess, my plea deadline day. I do believe that we have a plea agreement. My client lives in Houston. He did want to see if he could have one more reset to take care of some things with, he lives with his elderly grandmother. This plea is going to call for 6 months state jail time. So I guess he'd have to get down here, I guess, to do the plea in person so he could turn himself in. Is that how we would do it, Judge?
Yes. So is he accepting the offer?
Pardon me?
Is
He had told me he will. I just needed, I was talking to him on the phone. He couldn't get into the breakout room a while ago, but I've been talking back and forth to him on the phone. So I just need to relate to him, about what he needs to do.
All right, so do you have an idea of how much time, or you want to discuss with him how much time?
I would like to discuss with him, Judge, but he told me a month.
All right, so Ms. Ferguson on Mr. Moore, can I have a 30-day reset? Mr. Moore, on that 30 days, if you're going to be entering a plea, you'll need to come in person in the courtroom, okay?
Yes, ma'am.
All right, so that's going to be June 28th
Yes,
at 9 a.m.
I will give him directions, Your Honor.
All right, and are you coming in from Houston?
Yes, ma'am.
All right, I'll notate in the file that he's coming from Houston. So if any reason that he's late, the court will know it's because he's coming from Houston, okay?
Thank you, Judge.
All right.
Excused.
Well, Mr. Hill, do you need to speak with him?
I'll call him on the phone, Judge.
All right, then both are excused.
Thank you, Judge.
Thank you,
You're
Judge.
welcome. All right, bye-bye.
Bye-bye.
And Nathaniel Navy, if he's still on, can you please go back to the breakout room? David Looney's in there.
Benedict, there he is. Okay, I'm just now waiting on the plea. Do you have it? I'm giving you a workout on the knees, right?
Yeah. They tell me you already signed it. It's been filed. It
Okay.
was sealed, so they can't get it back.
Okay. All right, well, you need a copy of it.
Yeah. They tell me I go downstairs and get a copy of the order.
Okay.
Thank you, Judge.
You're welcome. Hello. Yes, you're on Zoom, then you're not on Zoom. I can't keep up with you.
Oh, God.
Hi.
Whitley,
Yes.
we have a plea agreement.
Mhm.
May we do it on Tuesday? But ultimately, I was just gonna ask for a non-PSI reset. Just gonna be a to-do.
Okay, I'm not here on Tuesday. So you probably want to do it today. If it's for me to do it and then for him to be set on another day for sentencing.
Okay. I don't know if she's gonna be able to do the paperwork that fast, but if she can,
Okay, all right.
you'll let her. You'll tell her?
Yes, and which prosecutor are you working with?
Miss.
Was it
my
Brittany
brain is-
Sparks?
Yes, yes,
All right, I will let her know.
okay. Now, there's some hard paper I could do, right? Hard paper.
Yeah, well, she's upstairs, so that's gonna be hard for her.
Okay. Judge, maybe you don't get some down because my phone's about to die, so I'm not gonna have access to my email.
Okay. All right, Luis Martinez.
Judge, I've conferred with Brittany. Mr. Martinez, my client, has a lot of cases, so she's going to have to go through the files. There's theft cases. She's going to have to reach out to with complainants. So could we get either a 1 week reset or a 2 week reset for her to do that so we can come back and get an offer?
All right, Ms. Fergus, can I have a 2-week reset on Julian Martinez? All right, we're gonna come back on June 13th. Mr. Martinez can be excused. He's 17D.
Oh, can I get anyone in a room with him first?
Okay, I will send you to a room with him.
Thank you, Judge.
I'll send you to room number 1.
Thank you.
You're welcome.
Hello.
Judge, this is Brittany.
Yes.
Is Joseph Acevedo doing his plea in person today?
Yes, he's here in the courtroom.
Okay, I'll start the paperwork.
All right, you're getting your steps in today.
Judge, this is
Yes.
Andy Fraley. Can you put me, I'm trying to check on Mr. Navarro. We got the last piece of the paperwork again. I want to make sure he fills out the paperwork correctly. Can you put us in a breakout room to finish that?
All right, I'm sending you to number 4. And Mr. Froelich, were you previously in a room?
I believe so, Judge. I had to log off for a second and log back on. So I'm sure I was with Lupe for a few minutes too.
All right, I sent you to number 4.
Mr. Navarro, thank you, Your Honor.
Mhm. And there's a Kyle Ernst in breakout room number 8, waiting for a prosecutor.
I went in there, Judge, but he didn't answer. He just had his screen blacked out. I'll go in there again. He never answered though. I said his name for like 30 seconds.
Okay, all right, thanks. And to the clerks, do you know what is happening with the paperwork on Mons?
Your Honor, I've just received the appeal paperwork. I'm going to sign that, and then I think it should be ready on my end.
Okay.
Judge, on Munns, we were just missing the consent to plead by video and the certificate of appeal.
All right, thank you.
On the 2 cases, yes.
All right, then, Ms. Blake, I'm gonna send you to breakout room number 2.
And I just signed those two, so.
Okay. All right, and the clerks, when you're available, if you go to number 2, to make sure that the paperwork has been signed. And I will sign it on my end as well. Number was Mr. Alexander Reset.
Give me 1 second, Judge.
Thank you.
I just sent you a chat.
All right, thank you. And Ms. Bergen, can you see where Mr. Kyle Ernst is?
I think he's in a breakout room.
No, he's not there.
He's in there, Judge. He just has his screen blacked out and he's not answering. I went in there again and it was kind of the same thing. He just doesn't have his screen on and he's not answering.
All right, Ms. Perez for Mr. Furness.
Yes, Your Honor, I'm here.
Yes, what is happening with his case?
I'm sorry?
What is happening with his case?
I had just finished talking to my client. I spoke to Ryan and I'm about to text or I'm about to text Brian real quick right now. He just came on.
If you want to need it, I'll meet you back in the breakout room.
Mr. Nady?
Yes, Judge. I was able to talk with, let me see, is it Miss Wilkes?
Yes, sorry,
Yeah.
sorry, Wilkes.
Yes.
There we go.
Hi, Caitlin Wilkes. Hi. We haven't seen you in a
Hey.
while. Hi.
Long time no see, Judge.
Yes. All right. What is happening, Mr. Paul?
The state's opposed, Judge, but basically this is a motion to allow my client to work and move out of county while his case is pending. It's still pending at intake, Judge. He does have a GPS monitor. He's on partial house arrest. He's allowed to work. What he does for work currently, he's a flight line modification mechanic for Boeing. He works on their 737 MAX program. He's worked in some form or fashion on basically airplanes and being a mechanic on them for the last 12 to 13 years. He's worked for Spirit Aerosystems in the past. He has a current job offer from Spirit Aerosystems in which he would need to report next week. He would like to accept it. It would call for him to move to Wichita, Kansas, Judge. That's where his mother lives. And so he would live with her. He would be able to appear for any court settings whenever they may be. His case, like I said, right now is still pending at intake. He bonded out on this case in October of 2021. So he's been, I think it was October 21st of 2021. His conditions were GPS partial house arrest, no contact with the complaining witness, random drug and alcohol testing, no possession of firearms. And to date, he's had no violations at all on his bond conditions. The cases that he's charged with, Judge, it's sexual assault of a child and prostitution, person solicited under the age of 18. My client maintains his innocence in this and that there was no sexual contact, but I have no, the only thing that I have uploaded so far is an arrest warrant, Judge. So it has been pending at intake for quite a while, and he doesn't have any support system here in San Antonio. So his mother does live in Kansas, like I stated. His mental health has kind of suffered just because obviously he's required to stay by himself where he lives, doesn't really have any contact with anybody outside of work. He got into a bad motor vehicle accident in January. So he's been dealing with that as well, Judge. And so I would ask if the court would be willing to allow him to accept this job and to be able to basically reside in Wichita, Kansas, while this is pending.
All right. When does he need to give notice?
He would need to give them notice as soon as possible, Judge. I believe he would need to attend an orientation on Tuesday, and his job would start on next, I believe it's Thursday or Friday.
The problem is that I need more information, right?
Okay.
And I don't know, since it's an off docket matter, I don't know if the state is ready to present that information to the court. You're on mute, Ms. Wilkes.
Are you there?
Yes.
Can you hear me?
Yes.
Okay, so I do have a lot of information for you. This case has been in the works for quite some time. He's not the only individual charged in this instance. It's a trafficking case. A brief summary of the facts are the defendant is Mr. Boyle asks for a prostitute to come to his hotel room and has sex with a 15-year-old girl.
All right, before we get into that, state, would you be ready to proceed on this if we're able to get a setting next week. To present
Proceed on.
information.
Oh, yeah, I mean, yeah, I can, but Judge, this is not even in this court. It's in the 379th. So I'm just wondering if maybe like. Mhm.
Oh, it's in the 379th, Mr. Navy?
And I've always seen that it was 187th, but I do see where it says, because it said 187th pre-hearing and then I guess 379th. Judge.
I think I had Norma transfer it in November to 379th.
Okay.
Okay, it's in the 379th, Mr. Navy. I'm sorry.
But correct me if I'm wrong, Judge. But I thought that if it was still pending at intake, I guess technically one court or the other doesn't necessarily have jurisdiction on it. So I think you would still be able to rule on it. Is that incorrect?
Well, the thing about it is, one, I'm alternate presiding, so I wouldn't mind ruling on it, but the problem is it's off docket, state's not ready, and we need to get a setting date for it. Because I don't have any information about the case. I have nothing before me.
Well, I can give you the information right now, Your Honor.
Well, what I'm being told by Ms. Ferguson, she's just texted me, chatted me, and she said both cases are in the 379. And I really don't like stepping on other judges' toes. So I'm pretty sure Judge Rangel would probably want to hear it. Mr. Navy?
Yes, Judge. I understand that. I understand your hesitancy, Judge. I would just request if you would consider this, considering the quick nature of the turnaround when he does have to report to his job.
Well, just one moment. Just give me a second. And just for everyone who's waiting for your pleas, the court has signed all of the paperwork. Everyone, just give me a moment. Are we on mute? Thank you. All right, could I see both attorneys in the breakout room? Ms. Wilkes, are you still there?
Yes, I'm here, Your Honor.
All right, I'm gonna send you to breakout room number 1.
Okay.
And Nathaniel Navy, if you would come to breakout room number 1, please.
Judge, can I interrupt for a second?
Ms. Wilkes, I just sent it.
Okay.
So my client texts me. You're trying to do both.
Parties on Navarro,
Yes.
who's
Yes,
the
Your Honor.
attorney for Navarro?
Yes, Your Honor. It's Andrew Freilich, and where did she go? It's Brittany Sparks.
All right, Nathaniel Navy, I'll send you and your client to breakout room number 1, and you can explain to him what is happening.
Thank you, Judge. I appreciate that.
You're welcome. And you all can be excused from there. Michael Villarreal, could you take up Victor Navarro for me, please?
Yes, Judge, as long as you walk me through it.
All right, thanks. Court is calling 2022 CR 5118W State of Texas versus Victor Mark Navarro. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
Andrew Freilich,
Defense.
Mr. Navarro.
For the defense?
Andrew Freilich for Mr. Navarro. Judge, you haven't, I'm not sure if I need to shout or if my microphone's working.
And are you Mr. Navarro?
Yes, ma'am.
All right, we're proceeding by video. Any objection from the state or the defense?
No, Your Honor.
Your Honor.
Mr. Navarro, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Court
Yes,
will
Your
find
Honor.
that- Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you counsel discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor. Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Navarro, I'm going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, yes, Your Honor.
Did you understand you have a right to have a grand jury hear this case? Your attorney also has a right to have a notice of this case within after 2 days of the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. I'm going to show you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, it appears you're proceeding on the information as presented. Is that correct?
Yes, Your Honor.
All right, Mr. Navarro, I'm going to show you what's entitled court admonishments. Did you review that with your attorney? Did you understand it?
Yes, yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, I did, ma'am.
You understand you're charged with the burglary of a vehicle with 2 or more convictions as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, we've discussed it, and
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Navarro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am. Your
Are you
Honor.
a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. There are no applications. The state is taking in consideration grand jury number 710099, night mag number 655444. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Your Honor. At this time, state offer states exhibit number 1 and its attachments.
No
Any
objections.
objections? Mr.
No.
Navarro, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just ask you follow the plea bargain.
All right, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. Take into consideration grand jury number 710099, NIMAG number 6555444. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am. Yes, I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what an weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
What was that? Repeat that, miss, please.
If you have a question over what a weapon or ammunition is,
yes.
you'll need to speak to an attorney. Do you understand?
Yes, Your Honor, yes. Sorry
All
about
right,
that.
we can go off the record. Mr. Navarro, good luck to you. It appears to me that you won't stop stealing. So what's breaking into vehicles. So what's going to end up happening if you continue on the route that you're continuing on? You're going to end up spending the rest of your life locked up and in jail, or either locked up in prison. Do you understand?
Yes, I do, ma'am.
All right, good luck to you.
Thank you
Number
very much.
17K Navarro can go back. Mr. Froelich, you're excused. Thank you.
Thank you, Your Honor. You have a great weekend.
All right, you too. Who are the parties on Donald Furnace?
Anita Perez. Judge, we're doing paperwork on it, provided the court has enough time. We just started paperwork.
No, I did not. Oh, yes. All right, thank you. All right, who are the parties on Ethan Byers? And then after that, it will be Mons.
Michael Villarreal for the state judge.
Natasha Torres on behalf of Mr. Byers, Your Honor.
All right, the court is calling 2022 CR 2351, State of Texas versus Ethan Byers. Could I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Natasha Torres on behalf of Mr. Byers.
And are you Ethan Byers?
Yes, ma'am.
We're proceeding by video. Any objection from the state or the defense?
And from the state.
None, Your Honor, from defense.
Mr. Byers, I'm showing you what's entitled defendants consent to appear by video. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Byers, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Hey, Your Honor, state's waiving count 1 and proceeding on the lesser included offense, count 2, which is assault, bodily injury to a family member or household member.
Any objection?
None, Your Honor.
Mr. Byers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family, or household as a Class A misdemeanor? The range of punishment is anywhere up to $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand that if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Byers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, family violence, household. Fine is set as $800. State recommends deferred adjudication. The hostility and aggression control course, affirmative finding of family violence, no firearms, and no contact with Daniel Lopez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
None, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 2 years and there'll be 80 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense of assault, bodily injury, family, and household, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers states exhibit number 1 its attachments.
Any objection?
Not objection.
Mr. Byers, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, it's your understanding you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes, Your Honor.
Excuse me, there's no hugging in the courtroom. This is a courtroom. This is not a dating service. All right, so miss, if you can move over to the side away from him, because it seems like we can't control ourselves. All right, did you understand again that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt. Just one moment. All right, there appears to be a mistake in the summary of the investigation, because the incident is alleged to have occurred on December 16th, 2021.
Let me check, Judge.
And in the summary, it says that they were assigned the case on November 16th, 2021. Has it been a long day or is my math wrong?
I don't know if you should be relying on me for math, Judge. So
Okay.
you just give me one.
I think there's a mistake of the date in the summary of the investigation, but what I can tell you, the report time coincides at the top of the form. So maybe the officer meant that he was assigned the case in November 2022. But let me read further to see the dates that I have. So everyone just give me a moment. All right, that was from Officer Bush. I do have the report from Detective Williams that has the correct date and time on it. All right, Brenda, the court will find that there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. My client asked if I could address 2 things during sentencing with the.
Yes, you may proceed.
Your Honor, I spoke with Mr. Villarreal. The agreement does state no contact with the complaining witness, which is Mr. Daniel Lopez. We understand that that's the agreement. However, if the court is inclined to perhaps modify at a later time to no harmful or injurious contact with Mr. Daniel Lopez, he is a family relative. And the other, I guess, issue that my client wanted me to bring is sometimes I know the court does not allow home care or health care provided as employment. He asked if he could address that.
Yes, I'll hear him address that.
Right, Ethan, why don't you tell her a little bit about why you would like to be considered for that?
Yes, Your Honor. I was in the process of becoming a healthcare provider for my grandfather, which is 80 years old, and he really needs help. I was just asking if I can maybe do that. I heard in previous cases that you tell them no employment as a healthcare provider. I was just wondering if I can possibly do that as a part-time job.
If you're drug tested today, what are the results going to be?
They should be negative. I did take a form of edible like 12 days ago of marijuana. I don't know how. I don't do that on a normal basis. But
All right. So I don't allow people who are in on probation in this court to be home health care providers.
Okay.
All right. So what's going to happen is it's going to be $800 fine, probated. Do you have any children?
no, ma'am.
All right. 2 years deferred education, hostility and aggression control course. There's an affirmative finding of family violence. There's to be no contact with Daniel Lopez. Once he's done the course, then the court will reconsider. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 80 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you get it, then 40 of those hours will be waived, or the 80 hours. How far did you go in school?
10th grade.
All right. He's to obtain his GED or do some type of trade school. And the court will waive the remaining of the community service hours once that's completed. There's to be regular reporting by Zoom or in person. Random UAs, field visits, one time per month. All right, Mr. Byers, is there anything else you need from the court in order to be successful?
No, Your Honor.
Probation, is there anything else that Mr. Byers needs in order to be successful?
No, Your Honor.
Mr. Byers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor. I had one more question.
Yes.
I don't know if the state of Texas or Barrett County offers any counseling classes through probation, or is there any way I can possibly get that kind of help? I just lost my mom, and it's been really hard.
All right, if you can get counseling classes from him, probation. And I know they can do Center for Healthcare Services. So let's see if Center for Healthcare Services, or he can obtain some counseling.
Yes, Your
Sorry
Honor.
to hear that, Mr. Byers. All right, probation, if you want to have him go to a breakout room to go over conditions. And Mr. Byers, I showed you the trial court certification of defendant's rights to appeal. Did you review that?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because it's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Byers. You need to make your mom proud, okay?
Yes, Your Honor.
All right, I'm gonna send you to breakout room number 3 with probation, and probation will go over conditions with you. And
Thank you.
Ms. Torres, you're welcome. And Ms. Torres, you can go to breakout room number 3.
Thank you.
With them, or either you can be excused. All right, Ms. Abrams, these 2 cases do not require probation. There's no application. All right, the court is calling 2020 CR 2516 and 2022 CR 2465, State of Texas versus, and I do not see Mr. Mons.
I think he's in the court.
Oh, Mr. Mons, if you can approach. Yes. Oh, no wonder you were hugged up because you're leaving. All right, well, hold that in your memories, okay? All right, the court is calling 2022 CR 2465 and 2022 CR 2516, State of Texas versus Brian Mons. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Angela Blake.
And are you Mr. Mons?
Yes, Your Honor.
All right, Mr. Mons, your attorney in the state are by Zoom, but you're in court in person. Any objections? State?
No objections.
Defense?
No objection.
All right, Mr. Mons, I'm showing you the consent to appear by video conference. I do realize that you filled out this paperwork prior. But do you have any objections to your state and to the state and defense being by Zoom?
No, Your Honor.
All right. All right, defense, in each of these cause numbers, did you receive all the discovery and did you review that discovery with your client?
Yes, Your Honor.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Mons, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Mr. Mons, in each of the cause numbers, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
And cause number 2022 CR 2465, you're charged with the offense of fraudulent use or possession of identifying information, 5 items or less. And in cause number 2022 CR 2516, you're charged with the burglary of a building with intent to commit theft. Those are both state jail felonies. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering these pleas, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements with this
Yes,
in
Your
each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes, Your Honor, we've discussed them.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mons, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Has anyone promised you anything other than a plea bargain agreement to get you to enter the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
In each of the cause numbers, your punishment is to be assessed at 9 months in the state jail facility. Both cases are running concurrently, and the state is taking in consideration 2022 CR 3152. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
In each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2022-2516, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And in cause number 2022 CR 2465, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Judge. State offers State Exhibit 1 and all attachments.
No objection, Your Honor.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court has reviewed each of the court is finding in each of the cause numbers that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments in each of the cause numbers, and the court in each of the cause numbers is finding there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor.
Mr. Bonds, in cause number 2022 CR 2516, the court will sentence you to 9 months in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 2465, taking consideration 2022 CR 3152 and cause number 2022 CR 2465. Court to sentence you to 9 months in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 2516, taking consideration 2022 3152. And each of the cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. All right, good luck to you. Do better, okay?
Your Honor, I apologize. I'd like to approach about one other issue.
Yes.
He did these resolution of these two cases actually resolved 9 total cases that he had pending with the county. 6 misdemeanors and 3 felonies. He had a pretty bad drug problem at the time, and then he went to Laurel Ridge in November of last year on a voluntary basis. I don't know, I know with the court, he's not entitled to that time, but would the court consider giving credit for the 1 month that he did there in Laurel Ridge?
No.
No, okay, I just wanted to ask.
All right, thank you.
Thank you, Judge.
You're welcome. All right, Mr. Whitley.
Your Honor, can I interrupt for a second?
Yes.
I've signed some paperwork. We have an agreement with Mr. Furness, and I think I'm just waiting for the certification of appeal. I tried sending a message to Norma, but other than that, we've signed everything.
All right, as soon as it comes to me, the court will sign it. I haven't received it on my end. So what I'll do is.
But I don't think she's aware. I don't mean to.
No. I mean, I don't have the plea paperwork from you. That's what I'm saying. It has to come to me and I have to sign it. I'm going to send your client to number 1. I'll send you to number 1, and I'll send Miss Ferguson to number 1 as well.
Okay, thanks.
And could the clerk go to number 1 as well, please?
Thank you, Judge.
All right. Court is calling 2021 CR 10284, State of Texas versus Anthony Whitley. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Judge Possibility, Your Honor.
And are you Mr. Whitley?
Yes.
All right, the state is by video. Defense counsel is in the courtroom. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Whitley, I'm showing you what's titled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Right. Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on count 1. We're going to waive count 2 in the repeater or the enhancement paragraph.
Any objection?
No objection, Your Honor.
Mr. Whitley, I'm going to show you what's entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams? That's a first-degree felony. The range of punishment is anywhere from 5 years up to 99 years or life in the prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Whitley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, your punishment is to be assessed at 8 years in the prison. The state is proceeding on count 1 only. There are no applications. The state will take in consideration 2021 CR 10282 and 2021 CR 10283. Did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No rulings, Your Honor.
Then Mr. Whitley, to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State offers State's Exhibit 1 and all attachments.
Any objection?
No objection, Your Honor.
Mr. Whitley, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Can you go on mute, please? All right, so just give me a moment. And Brenna, I promise we are leaving today. We're not spending the night at the courthouse.
Okay, thank you, Judge.
Did you make it, Mahia?
Yes.
Oh, okay. All right, we can go back on the record. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. What time are you asking for for sentencing defense?
Well, we're gonna ask for 60 days, but we know the court won't entertain that, so something like 35, 40 days.
And why does he need the extra time?
There's 3 young children that he's just trying to get them situated with mom and just do a smoother transition for, especially given this that just happened in Uvalde, just trying to get things in line, everybody be at peace.
All right, Ms. Ferguson, can I have a 30-day reset for Mr. Whitley, please? All right, so Mr. Whitley, Ms. Ferguson, oh, she's giving me 2 days. All right, we can do June 28th. All right, Mr. Whitley, they're going to give you a reset form for June 28th. And Ms. Ferguson, I sent you an email. Could you print that document out for me, please? All right, we'll see you back on June 28th, but just remain in the courtroom till they give you a reset form.
Thank you.
You're welcome.
I had a matter with Uvalde the day of the shooting,
Mhm.
but I was able to get a pass.
Oh.
Oh my God, I was like,
Oh,
wow.
wow. Yeah. You know, I always tell people when something like that happens, that means that there's something else that you have to do, that you're needed, you know?
Yeah, I was like, they reminded me in my office, they go, you know, you were supposed to be Uvalde. I said, oh yeah, the one who got passed. It was about time of the shoot. I was like, oh my God. You just never know. If
You never
cross this
do.
path.
That is just so sad. All right, on Montez, you're gonna get you're gonna get a new defense attorney, Mr. Montez.
Yes, ma'am.
So we're gonna recall you.
Okay.
Yes, I have it.
Doing it right now.
Yes, thank you.
I'm sorry, were you talking to me and I was trying to?
No, Mr. Montez, can you tell me if there's another attorney who's coming up on the list or?
I can.
I'm sorry to tell.
I know, right?
Yes.
Make sure they get discovery.
Yes.
Do I just assign an attorney?
Mhm.
Or do you want me to tell them who it is or?
We'll just assign it and recall it in 2 weeks.
Okay.
So what date do you want to recall it?
I think June 6th or 7th.
Let's do June 6th. Okay. Yes. All right, Mr. Montez.
Yes, ma'am.
Your attorney is unable to proceed with your case due to medical issues.
Okay, that's fine.
So we're going to appoint you a new attorney, but we're going to come back on June 6th. And at June 6th, you'll get a chance to meet your attorney. And that'll give him a chance to view whatever discovery he needs to view, because I don't want him to not have what he needs. Okay.
Yes, ma'am.
All right.
Thank you, ma'am. You have a good weekend.
Thank you. You too.
Bye.
Good evening.
All right. Thank you. You too.
Be safe.
All All right, and Ms. Ferguson, what is happening with Mr. Taylor? Brenna, I don't want us to be accused of running night courts. Like,
You better get us out of here quick.
yeah, I'm getting us out.
We don't want to give anybody any ideas.
No, we do not. Mr. Hill?
Yes, Your Honor.
We're gonna recall you for another date. Your attorney's not here.
Okay.
All right, Ms. Ferguson, on Mr. Hill. Can you give me a reset date, please? All right, we're gonna come back on May 31st.
Okay, thank you. Have a nice
You're
week.
welcome. You too.
That's one, Judge, right?
All right, thank you. Norma, who is Mr. Taylor's attorney?
It's in the chat, Judge.
All right, Ms. Ferguson, recall Mr. Taylor for the 31st. Mr. Taylor, we're going to bring you back on the 31st with your attorney.
I appreciate you, Your Honor.
All right, thank you, Mr. Taylor. And I don't understand why Mr. Garcia is here. Or Mr. Aguilar.
Judge, Mr. Aguilar, you asked me to bring him in. He's on the recall.
Oh, it was for Mr. Jimenez. And it was for a pre-hearing, and he wanted to discuss something with regards to his client. Mr. Aguilar, we'll have your attorney put that back on the docket. All right. So Ms. Ferguson, if you can get in touch with Mr. Jimenez so they can be placed back on the docket.
Yes, ma'am.
Thank you. And then Mr. Garcia,
Yes, ma'am.
who is his attorney, Norman? I don't have a file for Mr. Garcia.
It was Mick Aguilera and Sharon Thorne, but they said they were gonna come back to see me on Tuesday. We're gonna come back to court.
Yes, you're coming back on May 31st.
Yes, ma'am.
All right, thank you.
That was it.
Yes. All right, Mr. Furnace. And this is the last one, everyone. Court is calling 2022 CR 1259, State of Texas versus Donald Furnace. Could I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Anita Perez Garza for the defense.
And are you Mr. Furnace?
Yes, ma'am.
All right, we're proceeding by video. Any objection from the state or the defense?
No objection.
Mr. Furnace, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Furness, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding under the indictment as presented?
Yes, Judge.
Mr. Furness, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
All right, state.
Judge, I'm sorry. I think I'm supposed to waive something and
Yes.
I've done so many.
Waive one of the paragraphs. Because otherwise it's a habitual.
Okay, Judge.
All right, any objections to the state proceeding on a repeater offender enhancement allegation? Defense, any objections?
Well, yes, Your Honor, because we're pleading on the second.
No, he's charged with the DWI third. The state filed it as a habitual. So that means that his minimum will be 25. So the DWI third is a third-degree felony. And since the state is proceeding on it as a second-degree felony, then he's proceeding on a repeater offender paragraph, correct?
Oh, okay. I'm so sorry. Yes, Your Honor.
So any objections to the state waiving the habitual enhancement allegation and proceeding on the repeater enhancement allegation?
No, Your Honor.
All right, Mr. Furness, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yeah, yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand you're charged with DWI third or more?
Yes, ma'am.
It is normally a third-degree felony, but because the state is proceeding on it as a repeater, then it's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain? Wait, just 1 second, sorry. Just 1 moment. I'm sorry about that, Brenna. There's someone who's chatting and someone who's coming into the Zoom screen at the same time. Defense, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Furness, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
I'm going to show you what's entitled plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, you agree that you've been previously convicted of one or more felonies for enhancements under 12.42 of the Penal Code. Punishments be assessed at 12 years in the prison, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Council, are there any such motions?
No, Your Honor.
Into the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, state offer states Exhibit 1 and all attachments.
No objection.
How do you plead to that? I'm sorry. I'm telling you, there is something happened with this system and somebody keeps zooming in and out and the light is flickering. I don't know if it's flickering because they're telling us we need to go home. This isn't night court or what. Sorry about that. So, Mr. Furness, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and court will review the same. All right. So what I think that it's been a long day for all of us here. So I'm going to suggest, Brenda, if you're available, I know usually we are not doing it on Friday, but to me, everything happens for a reason and it's always for the best. So if we can come back on Friday, Ms. Perez, at 9 a.m. and we will complete this plea. Ms. Ferguson, I know it's late, but could we make sure that we have Mr. Furness ordered tomorrow at 9 a.m. to complete the plea? I know.
Yeah, do yours.
Yes. And it'll be just for him. He will be the only one on the docket. So Mr. Furness, we're gonna come back on Friday to take care of your plea then. We're gonna take care of it at 9 a.m. So we can make sure that we just do it at 9 a.m. I do have to qualify jurors, but I can take this up first.